We're going to have a Department of State report and update, and then a report on Open Meetings Act and FOIA, Freedom of Information Act presentation. Then we're going to take a break. Then we're going to discuss subcommittees. We're going to discuss thank you notes. We're going to move to new business, which is going to be a code of conduct. We're going to move into a communications director posting. And then another break, and then a discussion on general counsel next steps, then any final thoughts, and adjourn. So while it's a short agenda on the paper, it will be a little longer talking about. All set
Steve,
with that?
if I could just, so sorry to interrupt, Chair. The general counsel next steps is that's a typo. That shouldn't be there. So it should just go from communications director to final thoughts and next meeting agenda items.
Okay, thank you for that, Sally. All right. So we're up to taking a look at the minutes from the last meeting. I'm assuming that you've had an opportunity to look at those, with the exception of Juanita, who didn't get them because of the computer problem. Are there any corrections, additions, or deletions which we need to be made aware of? And since I had a number last time, I'm happy to say I didn't find anything this time. Doug.
No, I don't have any comments on it. I thought it was acceptable.
Okay. If there are no comments, I would entertain a motion to, Ron,
Steve?
raising your hand.
Yes, sorry. Just one correction, and that's on my name. They have my last name spelt wrong. It's Lange.
Not Langue.
Nope, not Lange.
Okay, we'll make that correction.
Thank you.
You know, once they get Langue in there, that you're Langue, you might as well change your name. Any other corrections? Okay, I would entertain a motion to approve the minutes as corrected. Cynthia? Second?
I second it.
Moved by Cynthia, seconded by Doug, all in favor of the motion approving the minutes as corrected, signify by saying aye.
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 Opposed, the same sign. The minutes are approved as corrected. Okay, next, we talked about public comment. There is no, nobody has signed up for public comment, but in order to make it known to everybody in Facebook and YouTube land, as well as others, we always try to explain what we're doing, and hopefully you can avail yourselves of. Because this is a virtual meeting, members of the public have to sign up in advance to address us, the commission. Staff at the Department of State will unmute each member of the public for up to 90 seconds on a first come, first served basis, so sign up early. This means members of the public will be called on in the order in which they signed up to address the commission. To those members of the public participating in public comment, please note that you will have no more than 90 seconds to address the commission. If you would like to submit your thoughts to the commission or participate in public comment in an upcoming session of the commission, you can email redistricting@michigan.gov, and the Department of State will provide your written thoughts to the commission. Public comment sign-up links are also posted on Redistricting Michigan social media pages on Facebook and Twitter @redistrictingmi. Now, I would like to recognize Sally Marsh, Michigan Department of State Director of Special Projects, who will call on members of the public to address the commission. There aren't any, but that would be the comments that we would go through in order to have public comment at this time. First up on old business at this time is a report from staff at the Department of State on the items we referred to them to discuss. Sally, updates and any questions?
One moment, commissioners. I'm making sure that that our live stream links are still working. One moment. Hi, everyone. Sorry about that. Just wanted to make sure our live stream links were working. So wanted to provide several updates to all of you about administrative items that are sort of ongoing. First is email addresses. We are very close to be able to provide you email addresses and having information on phones as well. We should be able to distribute email addresses next week. So stay tuned for more information on that, but we continue to work with the Legislative Council to make sure that that happens. And so it's my hope that we will have email addresses for all of you set up before the next several meetings in a few weeks. And I appreciate your patience on that front. Similarly, we are working on the specific details of how your compensation will work administratively and plan to have clarity on that as well 2 weeks from now. And that is why we did not put discussion of compensation directly on the agenda for today, as we hope to really have full information in several weeks. And I just want to acknowledge, I know this is probably frustratingly slow progress for all of you, but know that we are working on it, since all of you and this commission is new to state government. It's just taking us some due diligence to make sure we're setting it up correctly. So I really appreciate your patience on all of that. An update that we can give today on the budget, though, and your compensation is that today is the start of the fiscal year in state government, which is sort of a inside state government way of talking about the beginning of the year of appropriation of funds. And so I know Kathleen had a slide to show you all just to kind of outline the sort of key figures for your budget. The total budget allocated to the commission for this fiscal year is $3,149,400. And the governor's salary for this fiscal year is also set, which means that 25% of that salary, which is what you all are outlined as we've talked about in the Constitution, is $39,825. That's that 25% of the governor's salary. And so the just wanted to kind of illustrate to all of you, basically once that compensation is taken out of your budget for this fiscal year, so 39,825 times 13, subtract that from the 3 million that you are allocated, a little over 3 million that you've been allocated, and that brings you to $2,631,675. So wanted to provide those numbers to all of you, and like I said, we hope to have further clarity on the sort of administrative side so that you all can talk about compensation at an upcoming meeting. Another update, we are in the process of scheduling the webinars that you all requested we schedule. I'm happy to say that Matt Grossman, who's the director of the MSU Institute for social policy and public research, as well as Tom Avaco who's the director of the U of M Center for Local, State, and Urban Policy. You met them all in your first 2-day convening. They are able to help us facilitate expert speakers and facilitate these webinars. So more details to come on that, but I wanted to let you know the process of scheduling those webinars and ensuring that you have experts to hear from is underway. And just a few other things really briefly, and then I'll ask Mike Brady if there's anything I've forgotten. I'm sure there is. We have had, once you have your email addresses, which again, I'm hoping will be next week, we will be able to send along to you for your review some correspondence that we've received that is directed towards you all. So just be on the lookout for that. I wanted to let you know beforehand. It's not formal submission of public comment, but information for you to see nonetheless. And then job postings. The executive director position is posted. It's been circulated. It's on the website. I encourage all of you, of course, to circulate it in any networks you have. We are doing so at the Department of State. I know we've had several people email interested already. And pending your edits and approval to the communications director position today, we will post and distribute that along with the general counsel position starting Monday of next week, as was outlined in the schedule that you all approved last week. And those postings will be open through essentially the end of the month. The executive director position posting at the moment is set to close Monday, October 12th at 5 p.m. So Mike, is there anything that I missed that you would add?
Hi, good morning. No, I think that covers it all. The one thing I was just going to speak to is just to kind of reiterate what Sally said about folks working hard to get you all set up. I suppose this is, to put it in a certain respect, kind of the other side of the independence of this commission, and as important as that is, it's truly an organizing principle around the grassroots movement that led to this amendment. There are things. The Constitution offers some specificity about the independence of this commission that's, frankly makes this, very unique within state government. And so just trying to thread the needle between, that parts of this commission that, could, again, the commission being located within the legislative branch versus those parts of the commission that may be able to be serviced by, parts of the executive branch, and there's just nothing else like that. So in any event, folks are working hard. We're working closely with DTMB, that's the Department of Technology, Management, and Budget, as well as the Legislative Council in the legislature. And, we're seeing some progress, but again, for them, they've never seen anything like this before because there hasn't been anything like this before. So thank you again for your service and your willingness to be the first. And there's some of the things that I think just come, on growing pains or otherwise that come with being the first.
That's it?
I think that's it for our updates, unless you all have any questions.
Okay, are there any questions from any of the commissioners? Okay, hearing none.
Doug raised his hand.
Doug?
Yeah, I have one question. Sally, you mentioned that the executive director position was posted. Last week, we also discussed the general counsel position, and I think we gave approval for that to be posted as well. Was that done?
Yes, so that is per the schedule that you all voted on last week. That will be posted along with, pending approval or, your decision to post a communications director position. That'll be posted on Monday, October 5th, and be open for 3 weeks until essentially the end of the month. Like I said, I believe it's October 20.
Okay, thank you.
Okay, any other questions for the staff, Sally and Mike, or Mike? All right,
Just some
hearing none.
MC?
Sorry, Steve, I just wanted to appreciate that that you're threading a needle, and I appreciate your steps, the steps that you're taking to try to keep us independent and perceived as independent. Thank you.
It's our pleasure.
Okay. I don't see any hands waving or people talking, so we'll move on to Mike. We're having a presentation from Tom. I'm not even going to try.
As I tell
So,
people, it's pronounced Tom.
So I wanted to, thank you, Steve.
We want Mike, will you introduce Tom?
I'd be happy to. Good morning again. So Mike Brady, Chief Legal Director of the Michigan Department of State. I'm pleased to introduce Tom Quasarano, also known as Tom, from the AG's office, the Attorney General's office. Just brief background, Tom joined the AG's office, I believe in 1988, after having 13 years in private sector experience. And he's, dutifully served, I think this is now his 5th Attorney General. So he's worked under Democrats and Republicans alike, again, 5 different AGs. And, he's certainly some of the very best of the professionalized civil service that exists in state government and certainly in the Attorney General's office. So again, along those lines, I thought that he would be great to address this commission, given some of the questions that have come up about FOIA and more to the point about the Open Meetings Act. Those are both areas of specialty for Tom, and he is truly an authority on both of those topics. Also, again, just to acknowledge, given some of the questions before, and certainly the bipartisan and nonpartisan makeup of this commission, just wanted to emphasize that, for Tom, it's not about one particular AG. He's worked under 5 different AGs. As he described it to me, he describes his political philosophy as the extreme middle, I think is what he said. So with that, happy to turn it over to Tom to do a walkthrough of Open Meetings Act and FOIA. I'd raised with him some of the questions that had come up in our prior conversations, and he said he'd be able to speak to some of that, though has limitations that he can explain himself on how closely he can advise you officially, as a lawyer or not. With that, thank you, Tom.
You're welcome, Mike, and thank you, commissioners, to have me with you this morning. It's a very much an honor. One of the hallmarks of the Attorney General's department over these different administrations has always been to provide education to not just our client agencies, but to the public. The attorneys general have always encouraged the activities of staff and training and educating even in the university and college setting. I've been an adjunct visiting professor at MSU Journalism School for many years now, where I provide jurisprudence courses to future journalists in the news media law and ethics area. And one of the large areas that we cover are the Freedom of Information and Open Meetings Acts, because when it comes to information gathering for the media, those 2 statutes are certainly arrows in their quiver. So with that, I think, Mike, we had 2 handouts, am I correct?
That is correct.
Right, and did you want to put those on, or everyone has their copies there? And if everyone has the copy, I can just reference it without putting it up on the screen, whatever is preferred.
We could certainly put it on if that would be helpful for other folks watching. It is also on the website, redistrictingmichigan.org, and it has also been sent to each commissioner, but again on the website for the public's ease of access and review.
If you'd like to put up the FOIA handout, and then we can just scroll through it together, that might be helpful. Can you put that up on the screen?
Yes, we can absolutely do that.
Okay, if you want to do that, we'll start with that. I'll give some preliminary comments. In my class at the MSU, we do kind of a review of civics or high school government. We make sure that students are aware of the three branches and how government works, and that's important for all citizens to know. I quoted in one lecture from Obama's first administration. That administration put forth their commitment to transparency as other executive administrations have. Quoting from one of the papers presented, it said government transparency, and I'm not reading from that, what we have on the screen right now. But government transparency ensures the public's trust, collaboration, and participation. It promotes accountability, thus trust in what our government officials are doing. It promotes openness, thus collaboration in the work of our government. And it promotes diffusion of information, thus participation in our democratic process. Okay, a lot of words, but words that have a lot of extremely important meaning. So a government accountable to the people. An open government is at the core of the United States Constitution and of the Michigan Constitution. We formed a union to promote our welfare and secure our liberty. The Michigan Constitution essentially picks up on that. And all political power is inherent in the people. Government is instituted for their equal benefit, security, and protection. In other words, open government is part of the law of the land. And when we all know and understand that government has a overarching purpose, and that is to promote our general, our health, our safety, our general welfare, then how do we participate? How do we ensure that? And so we have these two transparency statutes in the state of Michigan. In 1966, the Congress passed the Federal Freedom of Information Act and a counterpart for open meetings called Government in the Sunshine Act. I've always liked that title. In Michigan in 1976, a decade later, the legislature, realizing that there were no codified laws that would promote this openness other than a string of case law decisions from the appeals court, they went forward and enacted the Michigan Freedom of Information Act, taking its name and much of the substance from the federal FOIA, and the Michigan Open Meetings Act, the counterpart, the first cousin, if you will, to FOIA. Whereas FOIA deals with the disclosure of tangible items, writings, records, electronic and otherwise, to the public. The Open Meetings Act allows the public to participate fully in the decision-making of government. There are over 10,000 public bodies in Michigan subject to these statutes. If a public body in Michigan, by public body, I'm talking about executive branch government at the state, county, and local levels, if they're subject to FOIA, they're not necessarily subject to the Open Meetings Act. If a public body is subject to the Open Meetings Act, it is likely subject to the FOIA. Why is that? Because the Open Meetings Act deals with those governmental bodies, popularly known as commissions, committees, authorities, boards, that collectively make a decision. A decision is made by a number of board or commission members, whereas other governmental bodies, as we know, are single head public bodies: the Attorney General, the Secretary of State, the Director of the Department of Health and Human Services, the Mayor of the city, the Chair of the local school board, the prosecutor for this county or that. So again, these statutes are worth noting together because there is an interplay there. All right, so looking at the Michigan FOIA, and Mike, I'll have you be my timekeeper. I also heavily involved in my church. I also preach, and as a preacher, I don't pay attention to time limits, so I have to do that as an attorney though. So with that said, the core purpose of the FOIA, it's very reflective. It is the public policy that we, the people, are entitled to all information regarding the affairs of government, the official acts of those who represent us as public officials and public employees, elected, appointed, hired, consistent with this act. Why? So that we may fully participate in the democratic process. And that is the connection to the First Amendment of the United States Constitution at the federal level, the Michigan Constitution at the state level, obviously. By that, I mean the First Amendment. I need to make sure that my class understands that the First Amendment is composed of 5 individual rights. To help them remember, I give a little poem, if you will: speech, press, religion, assembly, and petition. Of those 5, religion aside, those all deal with public participation, freedom of speech, freedom to diffuse that information. That brings in the press, the right to peaceably assemble. We're hearing a lot about that today. And the right to petition government. All of that is why we have FOIA and OMA. They play a role, not the complete role, but they play a significant role in the enforcement of those rights within the First Amendment. So fully participating in the democratic process ties us to the First Amendment. Mike, if you want to scroll down, we'll look at some definitions. I'm not going to go through all of it because our time is limited, but a public body means just about everything you can think of in the executive branch of government, includes boards and commissions, even councils in the legislative branch, does not include the judiciary. There are other means of accessing court records. They're called the Michigan Rules of Court. And there are other means of accessing public and private information, for that matter, when you think of subpoenas, requests for production of documents within litigation, interrogatories, depositions. There's all kinds of tools available to access information of public bodies. However, this is the wide open gate. This is the go-to statute where it pulls in all records of public bodies as the public's right to know. And the public record is defined as a writing prepared, owned, used in the possession or retained by a public body in the performance of an official function from the time it is created. That means no matter where the record originates, once it's in the possession of the public body, it's the public body's public record. It is not unusual to receive a citizen letter in our office. We get tens of thousands of emails and citizen letters, and we respond to each and every one. But some might ask that we treat their letter confidentially or private or with anonymity. We can't assure that. We can't honor their request because it is now a public record of our public body, the Attorney General's office. However, we'll see that the legislature allows public bodies to raise permissive exemptions. So for example, a FOIA request for a citizen letter, not identified as such, but just simply saying, I want all citizen letters for the month of August 2020, our FOIA coordinator, a term of art in FOIA, has the authority to redact personal names and addresses and invoke the exemption. So it's a balance of the overarching right of these statutes, the right to know, against the other equally compelling rights, the right to privacy, the right to confidentiality, the right to be secure in the homeland. You'll see that after 9/11, an exemption was added to balance the right to know against records that, if disclosed, would run afoul of our security. So it's a common sense approach, obviously. All right, moving on, I see here, Mike, that you point out that the Constitution, which created the commission, indicates that all of its material, all of its writings prepared, owned, used, etc., are public records. There's no question there. Article 4, Section 6, subsection 8 there tells us that. So in addition to FOIA, there is nothing in the law that said when complying with FOIA, you can't add additional transparency requirements. And certainly the Constitution is the premier law of the land. You just can't reduce transparency as a public body. All right, so again, everything in this FOIA is going to apply to the commission against the backdrop of the Constitution. If a public record is a writing, what is a writing? And you look at that list, what isn't a writing? It's ultimately all means of recording or retaining meaningful content. Any Post-it notes that you create, any emails that you generate, either on state devices or your personal devices. Personal devices can be accessed for forensic examination, not to sound too heavy-handed there, to determine whether any and all records responsive to a FOIA request that are otherwise not exempt are provided to the requester. And so keep that in mind. I always do. I jokingly refer to FOIA paranoia. I know that if in fact I'm creating a record as I'm creating it, as I'm typing on my keyboard for a purpose of our statutory charge as the Attorney General's office, this is subject to FOIA. Now, subject to FOIA doesn't mean disclosure. That's the presumption, the rebuttable presumption, subject to disclosure under FOIA. We have the presumption of privacy and others that we can then apply. But remember that in creating the records. In other words, if I'm typing some missive that is very lengthy, why not just call the person, the colleague, the client? Not document our work. We have to document our work. But oftentimes I think we create more records than we really need to. That goes hand in hand with trying to be more efficient in our personal and private lives, I'm sure. All right, so the section
Tom?
3, yes, Mike.
Yeah, on that particular point, I certainly hear you and understand that one of the things that the commission that we've talked about before is other obligations that exist in the Constitution that reference, when they're allowed to have, to discuss the work of, discuss redistricting matters. So this would be subsection 11 that talks about, the commission, its members, staff, attorney, and consultants shall not discuss redistricting matters with members of the public outside of an open meeting. It does say with members of the public, and so ultimately there'll be a question that, as the work goes on, there may be opportunities for kind of further clarification from your legal counsel. We just wanted to flag here, Tom, so you're mindful of that, and other folks, just as a reminder there, what Tom's speaking about is really, the four corners of the FOIA, of the Freedom of Information Act itself and the Open Meetings Act. And again, not in any way, fully weighing in on the specific language that we've discussed before, and undoubtedly we'll talk about later with respect to the Constitution.
That's correct. And so what we're doing here is we're reviewing two statutes as an overview, as they would apply to the commission, unless otherwise determined by the Constitution or other policies or best practices that the commission might come up with. In other words, you have to comply with the statute, but more importantly, you have to look at what enabled you, what created your existence. And that would always supersede the FOIA. And there's nothing in that Article 4 that in any way competes with FOIA and somehow or some way or other diminishes it. It just, I think, enhances the obligation the commission must follow, because part of the commission's purpose is to be extremely transparent with the constituency. Yeah. And so thank you, Mike. I appreciate that. And we'll touch on that too. So anyway, the Section 3 introduces us to the first party in a two-party relationship. FOIA is about relationship, the relationship between a public body and a FOIA requester. But who is the FOIA requester represent? Essentially, the world at large. That is, once the requester receives the information, there is no way, no mechanism in the statute to disallow ongoing dissemination, ergo the exemptions, because once it's out, it's out. It can be on the internet in seconds. So it really is giving records to the world at large. A public body cannot lawfully ask a requester what his or her or its motivation, purpose, or reason is, or the intended use. It's just essentially shifting the writings, if you will, the records from the possession of the public body, making copies, and then giving them to the requester. That's all it really is. All right, so and the public body has to allow the requester to either come in and inspect the records or make copies for them. We can move on here, Mike, to, I'm going to just skip through Section 4. Section 4 allows the public body to recoup its actual costs. In other words, the legislature did not intend taxpayers to subsidize FOIA requests. I can say that the vast majority of our FOIA requests at the AG's office are processed without fees because we have so many readily available documents, and following the legislature's encouragement, public bodies at all levels of government subject to this act are encouraged to put as many records as possible on their websites. And the legislature said, and you can simply give a direct link to that website and you've completed your response to the FOIA requester. And again, taking advantage of our technology, getting the information out as quickly as possible. A public body is not required to make a compilation summary report. We're going back to section 3 now, just momentarily. In other words, you're just simply getting the records in the form and manner that are held and retained by the public body. If the requester writes back, "Can you please explain this document?" There's no duty to explain the document or to create a document. It's not a deposition. It's not an interrogatory. You can certainly be a good public servant and respond to that question, but it's not required. So I'm going to ask Mike if you want to just scroll through section 4 real quick, get to section 5. I'm glad you know how to do this, Mike. I have not quite learned it yet. There we go. Section 5 introduces us to the second party. That is the public body. A public body shall respond in writing to a FOIA request within 5 business days after receiving the request. A lot of times requesters call it days. It's really business days. And business days mean that within that period of time, that 5 business days, you grant the request, deny the request, grant in part, deny in part, which is often the case because of hybrid documents, or take a 10 business day extension, after which time you do one of the first 3. So the idea is it's a short period of time to respond. It didn't say in granting the request, giving the records, because if you can charge a fee before the records are disclosed, granting the request just means we agree with you. These records are not exempt. They're subject to disclosure. They're subject to your request. No fee. Here are the records. In the interim, you need to pay a deposit, and then we'll process it and provide the records upon paying the balance. So there is a little bit of a financial transaction involved, if you will. If you don't respond at all, it is a denial without a reason for which punitive measures against the public body may be taken by the plaintiff now in court, the requester becoming the plaintiff. Can we go on there, Mike? As I know, let's see. So section 6 introduces us to an actual position in the law, the FOIA coordinator. The FOIA coordinator is the only person that can deny a request and process the request. It can be designated, another person can be designated to do that in writing, but the FOIA coordinator is an essential part of our government. Section 10, if you have rights, you have to have remedies, and if there's an allegation of violation, these are the remedies the public has. You may appeal to the head of the public body. So the appeal, now Mike, I'm not sure how the setup is yet for the commission in terms of who's going to coordinate FOIA requests that involve the commission, or who the head of the public body will be. And those are matters that, certainly you'll take care of, the commission will. But you can now appeal to the head of the public body. You don't have to, but it makes sense because it gives a new set of eyes on what was denied and to make sure that the denial was substantiated in the statute. Or you can go in the state case to the Court of Claims. For county and local governments, it's the circuit court. And it's a trial court action just like anything else. You have all the elements of discovery, depositions, whatever. Right? And the thing that we want to avoid at the state level as counsel for the state public bodies and commissions and boards is to avoid litigation. I'm proud to say that the amount of litigation we have is extremely low, considering the literally tens of thousands of FOIA requests hitting all the state departments. I don't want to quote statistics that I'm not sure on, but I think state police told me one time they have 10 or 12,000 a year. That's just one department. And they have to get them out in a timely manner. So at any one time, we might have 4 or 5 FOIA lawsuits. That's not bad. And I thank all the hard work of our public servants that keep in mind their responsibilities and are very detailed in their responses. We assist them in that way too. Training is very important. We do training with all state FOIA coordinators annually through the Civil Services Training and Development Division. They are very happy. Our agencies are very happy they have that opportunity, right? So there are some penalties and fines, and I like to think that we don't have to worry about those, but we can go on, Mike. I know our time is limited. Section 10A now introduces amended language that allows a public requester of the public to appeal a fee. If they feel the fee did not comply with Section 4 or the policies and procedures of the public body, which the public body must have policies and procedures posted, made available to explain how they charge. What is the threshold above which they charge and below which they do not charge. Right? So that's all in this statute too. We can move on, Mike. We do FOIA training, as I said, for FOIA coordinators. That's a 4-hour course. So you can see that's pretty detailed. We're not going to do that here. Then we go down to section 13 right there in that page. What we've done is taken, I think we're up to 27 exemptions now. They ran out of letters of the alphabet. We're now to AA. But all of those records can fit under any one of these 4 general categories. We take the language actually from the privacy exemption. So any records, the release of which would constitute a clearly unwarranted invasion of individual privacy. Home addresses of a citizen, home addresses of state employees for that matter, your home addresses. What does that have to do with me fully participating in the democratic process because I asked and received your home address? Medical records, social security numbers, all those things that common sense tells us, and the federal government and state government laws specifically might tell us are not subject to disclosure. Now we're talking about under FOIA. I'm not talking about subpoenas and all those other types of things. All right, so those 4 categories, you'll see then, if we go back up to the categories, I won't go through all these details. So there we go. So records or the release of which would impair the safety or security of a public body. You know, MDOC, Department of Corrections, is not going to give blueprints out willy-nilly to FOIA requesters, for example. Public policy, attorney-client privilege, doctor-patient privilege. We have medical records, doctor-patient records with the state of Michigan. We run hospitals. So any of those things, the deliberative process privilege, a privilege that the commission might find would be invoked in terms of a back and forth opinions leading to something. Again, you're under a greater transparency requirement than other public bodies would be. So everything I say here, I caution that it has to be against the backdrop of the Article 4. Records exempted by other statutes. FERPA, Family Educational Rights Act, Privacy Act, HIPAA, name some federal ones. The State Revenue Act, no public body may give state records, government records used in the administration of a tax. That's a 5-year felony if you give it out. So we see this constant balancing between the right to know, the overarching right to know, and the right to all these other matters that the government says we have to remember these other rights. We have to balance them, okay? Mike, if you want to just get to the bottom there, I'm not going to go through all these. Please read these as you care to. Any questions, Mike, of any of the commissioners on this material, please, by all means, get it to us, and we will help you every way we can. So you see there, that's the balancing act. All of these exemptions balanced against the right to know. Right? And then I think we can keep going, Mike, unless you see anything there. And then section 14, the last section, says a public body is obligated to do what? The obvious, separate the exempt from the non-exempt and make the exempt available. The non-exempt has to be explained in great detail by the public body. I always tell our agencies, you're explaining to the FOIA requester, but you're also explaining to a yet to be named trial court judge and a yet to be filed trial court action. Our responses, our written responses, should be a stellar example of a great exhibit. In other words, the judge can see what the request was, read the written response, and immediately have the picture of what's going on here. That helps the court to come to a decision that's well founded. All right, do you want to go to the, unless there's questions on this, we can go to the OMA. I know it seems like I'm rushing, but I do want to make sure there's times for questions and answers. The Open Meetings Act. Right, the Open Meetings Act is not it's comprehensive, but it's not as long in pages, if you will, as the FOIA, because the FOIA is dealing with so many records of public bodies. The OMA deals with the meetings of a public body. For example, generally speaking, the Attorney General's office is not subject to OMA. Now, if we house a commission or a committee or a board, yes, they would be. This is for those public bodies, I reiterate, that make decisions collectively on a board of 3, 4, 7, 13 members, for example, as with you. So the OMA's basic intent, it's not as reflective sounding as FOIA's, but it does say to promote government accountability, openness in government to be fostered, to enhance responsible decision-making. Sounds a lot like what we read from Transparency in Government at the beginning of this lecture, if you will. Key definitions, public body is not as comprehensive or extensive as FOIA. It deals with commissions and committees and subcommittees, authorities empowered by state constitution. You can relate to that. Statute, charter, ordinance, all right? And what is a meeting? It's the convening of a public body, the quorum being present to deliberate toward or rendering a decision on public policy. Public policy is a very broad definition. Decision means a determination, action, vote. We most likely think of it as a vote. All those things that ultimately effectuate or formulate public policy. So just about everything a public body subject to this act does has to be done at an open meeting. Your commission shall be done in an open meeting. It's very clear. There's a question that Mike and I talked about a little bit, and I'll bring it up here. In short, the OMA requires that all decisions and deliberations, those are words in the statute, must be made at a meeting open to the public. Decision is defined in OMA. Deliberation isn't. So it's a practice. Those of you who are attorneys are familiar with the law. You can go to dictionary definition. What is a deliberation? Long and careful consideration, etc. Right. So decisions and deliberations must be done in an open meeting. What does that imply? We're going to see here in a moment as we scroll up there, Mike, if you will, or Sally, if you're doing it. Who either is doing it? Thank you. If you scroll down, scroll down to the next page. We have to have public notice. That's right in the Constitutional Article 4. You must give public notice. How can it be an open meeting if the public isn't informed of the meeting? Right, so that must be followed. Now there is a unique thing, and almost somewhat unique. It's an Open Meetings Act, and then there's a provision called closed sessions. Well, this is the counterpart to FOIA. Exemptions to the premise that records are subject to disclosure. So it's a balance here. So there are permissible purposes, very few, that allow a public body subject to this act to go into a closed session. You go into closed session to discuss, and you may deliberate, but you cannot decide. If you decide in closed session, it's a violation of the law. Closed session minutes are protected by disclosure. It's a misdemeanor to disclose them. There, Mike posed a very good question. It's one that might have to be looked at a little bit more. So the commission shall conduct all of its business. Does this mean that the commission is not allowed to go into closed session? Well, I'm reluctant to just throw out an opinion right now because anything I say is not the formal opinion of the Attorney General, but we do provide division level advice, the division level memorandum of advice to client agencies. This is a very good question. Again, having looked at Article 4 for the first time last week and the early part of this week, that's not clear to me. It doesn't mean it's not clear to another assistant AG or to the commission itself, but it's a good question. Why would you need to go into closed session? When you look at the permissible purposes, I don't see any that really might apply to the commission. It might apply to other boards or authorities or commissions. So one of the examples is you can go into closed session to discuss an attorney-client privilege memorandum of advice. So I pose this hypothetical: if a memorandum of advice was requested by the commission from the Attorney General's office, you can waive the privilege and discuss it at an open meeting. But if you wanted to invoke the privilege, what do we do? Right. So I'm an honest attorney, believe it or not. I'm an honest attorney. I don't know the answer to that for sure. I can speculate, but I don't want to do that. Okay.
Tom.
Yes, please.
The thought that came to my mind in reading this was in the event of a human resources employee action of some description, the employee has the right to ask for a closed session to have their case discussed. Typically, when you're going to fire somebody, they also have the right to have it in open session. Would not that employee's right override the Article 4 mandate?
Well, again, Article 4 refers to all of its meetings, but I keep seeing the word redistricting matters of redistricting. Now, there might be some function of the commission when it comes to ministerial functions, administrative functions. Again, you're correct that a public employee who's going to be disciplined, et cetera, may request a closed session. There's debate among attorneys whether the public body has to honor the request because it's pro-disclosure, pro-open meeting. But that aside, if the commission found itself in a situation dealing with a personnel matter where that request was made and the commission wished to honor the request. That's, again, I'm not sure because of this, all of its business. But then later, as I say, and I'm repeating myself, Mike, your thought too, it talks about its business being redistricting matters. That's the reason it exists. But again, as a public body composed of human beings and those who are working in administrative roles, supportive roles, you may have a personnel issue. So that might be worthy of our, of whatever division, Mike, you we will be working with you sort of as House counsel might want to address, to do it now in advance of the question actually coming to rightness. All right, and I regret I can't give you something more certain, but there's not that many commissions and authorities that were established by Constitution with the focus on full transparency and balanced approach to its decision making. So I'd be reluctant to say, oh, I don't see why you couldn't go into closed session. There's been no real research done looking at the legislative history, looking at all the records that we would find in terms of the legislature amending the Constitution. There's a good lawyer answer for you. Mike.
Excellent lawyer answer. And my question, my guess would be if we looked at the legislative history, they never even thought about it. So.
Steve, I have to tell you, we've come to that chasm many times. It's nice to have a bridge to cross it, but sometimes you're at the cliff and you go, they didn't finish it. Anyway, Mike, do you have a question?
I have a response or at least a thought on this. So,
please.
I mean, a couple of things. One, of course, this isn't a question of legislative history here because this was not enacted by the legislature. This was a popular referendum. I did speak with the drafters of the some of the folks who were involved in drafting this language and who had been legal counsel and otherwise, just involved in that whole process of voters, not politicians, between last meeting and this meeting in anticipation of, really in response to the questions that this commission posed to me last week in anticipation of this discussion today. So, I could speak to that. They certainly talked about, they felt like their language was very clear and that for them, and this is not a surprise to anyone who, is familiar with any of this, that, for them, it was really just about, they wanted everything to be in the public and be open. That said, I think the public record in terms of what that group and other folks who worked on it, wanted, I think that's pretty clear. I think, as a matter of law, I guess I'd say that there's still the question of what does the constitutional language actually say? And so, speaking about the intent of the drafters or, whatever else, I think, a lot of the jurisprudence and constitutional analysis will often talk about, what did the word mean in its common, what do the words actually say? What do they mean in the common understanding? Because it wasn't the people who drafted it. Stuff gets drafted all the time that's not enacted in the law. What matters is what, each of us as voters here in Michigan, when we voted for or against, what did we think that the words in the Constitution actually meant? And that's, again, a distinct question that just further, acknowledge that question without, fully answering it. I did want to, Tom, draw a distinction. You mentioned at one point that, talks about not discussing redistricting matters. Well, I just want to contrast. There's subsection 10 and subsection 11. Subsection 10 is talking about meetings, and it says, each committee begins with each commissioner shall perform his or her duties in a manner that is impartial and reinforces public confidence. Goes on to say, the commission shall conduct all of its business at open meetings, period. So there's that. There's nothing about redistricting there. It's all of its business at open meetings. The second, to contrasting that with subsection 11, which reads, the commission, its members, staff, attorney, and consultants shall not discuss redistricting matters with members of the public outside of an open meeting of the commission. So I think there's a difference there that the drafters are seeming, trying to get to between the commission conducting its business, all of its business, without qualification, further qualification or limitation. That's the language in 10 versus the discussion of specifically redistricting matters outside of an open meeting. And so there's different things between, like if someone contacts you and wants to talk about the executive director position, and someone calls you and says, hey, so-and-so applied, they're really a great candidate. That's a discussion that's outside of a public meeting, but that I don't think would be covered by subsection 11, because that's not discussing redistricting. That is not arguably also would not be covered by subsection 10, because you're not conducting any business. You're simply getting someone's calling and giving you individually some sort of feedback about somebody, positive or negative, but maybe somebody who's applied for a position. So again, just keeping in mind that, Tom, you're right, the discussion of matters is limited to redistricting matters, that's an 11, but the conducting of business is all business is what subsection 10 talks about. So this may be clear as mud, but I just wanted to flag some of those things.
No, Mike, thank you. Thank you very much. I'm sorry, finish, and I just have one thing to.
Well, and the last thing I was going to say is that given, some of the, I'm not sure there's an immediate question that's before this commission right now. I do think Tom's counsel is sound, that it may make sense for this commission to engage this question and get an answer before you actually need to know what that answer is. And, he's offered, I think, that this commission could ask for a division level review by folks at the Attorney General's office. That would not be, for those folks who are concerned about whatever else, that's simply one, some attorney's review. It would give this commission some, legal counsel in a way that, again, I can't offer to you, Tom individually can't offer to you. You don't yet have other legal counsel. So I think really the question is, you can either wait on this question until down the road when you have your own lawyer, in which case, in the interim, I think you really probably need to default to everything being an open session, everything being public, which is what the Constitution says. The one reason that some of you, but I didn't hear all of you by any means in prior conversations raise this question was because of your pending, you're about to be hiring an executive director. And if you think you might want to, or even would be allowed to go into closed session, whether that's even a good idea from a policy and public perception, then you might need to get this analysis sooner than later. And the division level analysis from the AG's office may allow you to do that. Again, that's a question of, can you do it, not should you do it, not is it a good idea to do it.
Okay,
Doug,
thank you.
you had your hand up.
Yes, so your recommendation, Mike, is that everything's public at this point. So if we could create a committee, as I think we're going to do later today, even that committee needs to be on a public session. And that committee is for the executive director, I believe.
Is that a question for Mike?
Yeah, the question's for Mike. So you're recommending, Mike, that everything goes public at this point until we get further clarification?
Perhaps essentially. I think, at the very least, just saying, if you were going to go and if you wanted to go into closed session or do something else along those lines, then I would just advise you, again, not as your lawyer, but just as a lawyer, that doing something like that, you should be doing that on the basis of legal advice. And I'm just noting that you have not received formal legal advice along these lines. And so if you act other than with formal legal advice, you're out there potentially on a limb. And again, a lot of folks are watching this commission, and be an easy target for somebody to come after you.
Okay.
Mike, just to respond, thank you for clarifying the Constitution versus legislative approach. I think we were using legislative history more as an analogy. In other words, going behind the background behind something. That's very clear. And the idea that no individual member of the public can communicate with members of the commission in full or individually, I think is very important. Where the language is saying is that when we speak to the public, it's all the public that chooses to be part of the communication, two-way communication. So that's somewhat unique language in there. In other words, that would be a meeting of a commission member or members, all or some, with a member of the public. That would be not an appropriate way to meet. Is that right, Mike? In other words, all those communications have to be done at an open meeting for which the public is invited. You have public body members and members of the public and a posted meeting, a noticed meeting, and that's the only way that would occur. Just as a quick side note, advisory bodies, sometimes called subcommittees, whatever, presidential search committees, you've heard of those sort of things that are composed of less than a quorum of a public body, are not subject to OMA because they cannot make a decision. This is different though when we come to Article 4, and I would default to all business, as Mike pointed out, being done at a meeting open to the public. You could have a subcommittee composed of less than a quorum by definition, and still agree to have the meeting open to the public. The statute doesn't say thou shalt not have an open meeting of a subcommittee. You don't even see that term in the act. In other words, if all business is conducted at meetings open to the public, certainly when there's a quorum of the commission, but even if it's less than a quorum, you can post it as a meeting. As a matter of fact, just as a side note, Governor Whitmer's executive directive encouraged that we follow certainly the minimal transparency requirements of these statutes, but to enhance them whenever we have the opportunity to go above and beyond on that. Okay, I'll just go on to the minutes. Of course, the only way to be able to memorialize what went on is you have minutes, and there's requirements about minutes, certainly. You have rights, well, you've got remedies. Unlike the FOIA, there is a criminal provision. There's a misdemeanor provision if it's determined by a court that or prosecutor in court that there was an intentional violation of the act. This is a very rare remedy that I've seldom seen come to fruition. Most public bodies make mistakes. They're chastised for it. They have to pay actual attorney fees to the member of the public who sued or whoever the plaintiff might be. But what's interesting and I really give credit to the legislature in 1976, where they included at the beginning of this statute a mulligan, a do-over, that if there is an action, a lawsuit taken against the public body, that public body may, without any admission of liability, reenact the disputed decision in compliance, and that cures the deficiency, that cures the defect. That actually pulls the rug out from under the litigation. Because they took action. We have on a couple occasions encouraged public body clients that were accused of violating this statute, not with a lawsuit filed, but just by a protest letter, whatever, to reenact the decision. It's a heavy sanction in and of itself. You have to go back and do everything all over again. But nonetheless, the idea here is the legislature wants the people's business to move forward when it comes to decision makers composing commissions, authorities, committees, that sort of thing. Mike, I think that's the last page, is it not? I think that if you want to go, yeah. Was there anything else with that handout, Mike, that you added? I didn't see anything else.
No, I just called out a couple spots in the Constitution, some of the constitutional language.
No, and I'm glad, really quite glad that we were able to bring up some questions that will need a deeper review, more extensive review. If it was all easy and could get done in the first 20 minutes of meeting, that would be remarkable. It usually doesn't happen that way. Anybody have any other questions on either of these statutes? If not, I was going to leave you with a couple quotes. Any questions?
Tom, excuse me, I don't have a question, but having I never litigated a Open Meetings Act, but I litigated a few FOIA cases, and just kind of an aside for everybody, and you just mentioned the actual attorney fees. That's why people come after commissions, public bodies, et cetera, for OMA violations or FOIA violations, because the attorney makes thousands of dollars on these cases, and that gives them an incentive to come after people, because if you lose, it costs you a lot of money.
Well, and really, when you think about that, you have to pay the prevailing plaintiffs filing fees, and it does provide for some punitive damages and other types of damages, but the attorney fees can be very high because the hourly rates that are charged. And the FOIA says you're entitled to your reasonable attorney fees if you prevail in full, and possibly if you prevail in part, and almost as your actual fees. But as a private practitioner, 13 years long before my 33-year tenure here, I always thought that my my actual attorney fees were reasonable. So I'm not sure the distinction between the two terms. Steve, did we have any litigation together? I don't. Your name sounded familiar to me, but
I didn't see you the last time I did one up in front of the Supreme Court, but
yeah, interesting.
I always negotiated a substantially higher rate in my contract for these than I did, but
Well, like I said, I promote all the professions, that's for sure. Well, I'm going to just share a couple of quotes that I share with my class. I present to my class. James Madison was prolific when it came to open government. I mean, if you've ever seen the Madison Memorial, there's plaques of all of his many quotes. And a couple here is, knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. He said, nothing could be more irrational than to give the people power and to withhold from them the information without which power is abused. And finally, the advancement and diffusion of knowledge is the only guardian of true liberty. I think every journalist probably has that on his or her wall, because that really is talking about freedom of press and of course freedom of speech and the other freedoms we talked about at the beginning of this. So not to make this too academic sounding, but those words are important. We have to remember that, ultimately, who is my boss? Who is my boss? I just share one last thing. I was telling Mike possibly, we get a lot of citizen inquiries, and sometimes we'll get calls. Mostly everything is in writing, but if I take a citizen call, we tell them that we can't provide legal advice. Steve, you appreciate that. You can't, you have to go to your own attorney. Usually at the end of the conversation, they thank us for the legal advice, nonetheless. And they thank me. And then a couple times I said, no, let me thank you for putting food on my table. And there's this 3 seconds of silence. And then I get the comeback. I've never heard that from anybody who worked in government before, and I made it clear that we are here to serve the public. We're here to serve the populace. And we keep that in mind. And I know that you share that. And the work of this commission is so critical. Anything else, Mike?
MC, I see a question.
Yeah, and I think Cynthia had her hand up too.
Oh, okay.
Forgive me. Cynthia?
Well, I just had a question. I think it was brought up in an earlier meeting, but if we're using our personal computers to do this public work, does that cause a problem for us potentially down the road?
Well, again, the question being using personal devices to do state business. That's not uncommon. Some agencies provide a unique state-issued device for its employees who need to communicate 24/7, let's say. There is case law that indicates that no matter where the public information exists, it should be accessible. In other words, it's not location of the records, it's the character of the record. So that doesn't mean that any personal information on your device, computer or phone, is subject to FOIA disclosure. Unfortunately, however, to be able to pull the state records off, and a FOIA coordinator would work on that, not the public at large would work on that. You need to put the information, the bucket of personal information versus the bucket of public information, public records, if you will, to become publicly available. Those devices could be, as I said, I use the term forensic examination, meaning that a FOIA requester, now plaintiff, in a trial court says, I do not believe when they say that they only took from the personal device the public information. How do I know that was the case? Now, we have provided for our clients, or our clients have actually provided, but at our request, affidavits, where you say, after a review, I swear that this is the only information on that. Trial court judges usually are impressed by that, persuaded by that. They're not looking to get into the personal information. But it does pose a little bit of discomfort sometimes to think that I've got both public and private information on it. So I'm not suggesting or recommending anything, but to answer your question, I'll just leave it with that expression. It's not the location, it's the type or nature of the record. Does that help, Cynthia?
Yeah.
At least answers the question. It doesn't allay any concerns. I thought, is it MC had a question?
Yes, thank you. I just wanted to acknowledge, I appreciate that the offer that may have been couched. I am interested in trying to follow up and understand if there is a way for us to get a hearing on subsection 10 and 11. I said hearing, I don't know if that's the right term, but get some determination before. I want to use our funds wisely, and I feel like we potentially protect ourselves from litigation if we have some sort of determination. And I just wanted to offer to our chair that I am interested in that and appreciate the offer, if that was an offer.
Yes, what I was suggesting is that the Attorney General's office, as the attorney for the state of Michigan public bodies, we do work with our client agencies. We have a relatively large staff. We're one of the smaller departments, but we have like 20 some divisions. So I'm not sure, Mike, if a certain division has already been assigned or will be working with the commission as, I use the word house counsel. I'm in the state operations division. We do a variety of things that include advising in FOIA, OMA. We also do procurement, the contracts, the DTMB technology area. So we have enough attorneys to cover all the areas of law necessary. So I'm not sure it's going to be my division or even myself. Again, I'm a generalist, and that's why I was so happy that Mike was here, because Mike's the specialist. He knows the article much better than I do, at least at this juncture. Mike, you were going to comment?
Tom, in response to that question, there's not a specific division that has already been assigned here, nor do I think will there be a division assigned for this. As is noted, this is, of course, the Independent Citizens Redistricting Commission.
Sure.
They have the ability to contract for legal counsel, among other types of assistance and specialization. And the Constitution specifically does reference their ability to hire attorneys. That said, it's a little bit of, as with everything, it seems like at the moment with this commission, chicken or the egg, especially being the first time. I think in 10 years, when the next commission seated, there will be, folks will be able to look back to this experience of this first commission and have, more of a sense of how to move forward. There may be some existing legal memoranda or other things that will be able to be passed on kind of right out the gate. So that's, kind of where they stand. I think the question would be for this commission, MC, I think, what you're referring to is Tom had mentioned, not a formal AG opinion, which is actually a term of art that goes through a distinct process, but rather Tom thought that there may very well be able to be kind of informal, I don't know, it's very practical division level advice that would not be necessarily the formal advice of Attorney General Dana Nessel, but rather of the division attorneys who are part of the professionalized civil service who predate the current Attorney General and go after, and just like Tom and other folks like that. And so if this commission is interested in that, this commission can, you make the motion, and Tom happens to be here, I can certainly, relay this and would relay this to the to the Attorney General's office and find out like which division would be the right division to engage in this question. And then they could provide some basic, review on the questions that are before, before this commission, and and then they could come back and advise this commission at a future meeting on that. And if that's something that you'd be interested in doing, you can make that motion. We can certainly take it to the AG's office. I think that I suspect that they'd be happy to assist in this respect. But again, that would be, in my mind, I see it as more of a kind of a one-off at this point in the commission's creation and formation, because you don't have your own legal counsel yet. And I definitely heard the conversation last week of various commissioners making, at least what was clear to me, was making clear that you all, intend to have your own legal counsel as the Constitution allows you to. And so I think it's only, in my mind, kind of the chicken or the egg question. Do you just do everything in open, in which case you don't really need to get the legal analysis on that at this point? Or do you, as an interim step, ask the only attorney you can right now, which is the Attorney General's office, for some kind of division level of analysis to be able to give you options right now until you have your own attorney in place?
Thank you, Mike.
And if you decide to do that, there'd be a motion and a second.
Yeah. Thank you, Mike. Before that, then, thank you for pointing that out. I was not aware that there was the provision for retaining counsel. That would be essentially then your house counsel. That's not unique to the commission. There's some other examples of that in government. And again, I want to caution that I don't want to overstep any boundaries in terms of what I'm saying here, but in the interim, certainly we can, as we're doing here today, this is a presentation, this is not legal advice, but nonetheless, we will play that role. Did you need me to stay on for any reason? I hear that you're going to start going into commission business, other commission business now. Did you need me to stay on for anything, or I'll leave you to your
Yeah,
important work?
you've answered my question. Thank you.
Okay, thank you, MC.
Unless there are any other questions, not seeing any, I would like to thank Tom for being here and providing us with a very enlightening recitation of the Open Meetings Act and the Freedom of Information Act. Certainly, the time that was spent gives us a nice overview. It doesn't delve into the weeds like I'm sure Tom has done on many occasions, but at least maybe we know now to recognize something we ought to think about before we jump in. So again, thank you, Tom. We appreciate it.
Thank you, Chairlet. And again, this is my pleasure to be with you all. And with your leave, I will leave. By your leave.
Cynthia, you were waving. You have something for Tom before he leaves?
Certainly, I'm not trying to rush off. I just don't
No.
want to take up all your time.
I was saying thank you, bye.
Thank you, Cynthia. Certainly, my pleasure.
All right, we're at the break time for a 5-minute break, and we'll be back at 10:27.
Steve, I'm not sure if you saw the chat, but Aaron and Brittany had to leave us temporarily.
I did. It looks like we're all back that are going to be back. Welcome back, everybody. And the next agenda item is subcommittees. We had discussed subcommittees previously, specifically to review executive director position and any other positions, which obviously would be the public relations, communications director, and legal counsel. So we're going to open that up for discussions. Doug.
Yes. Yeah, I think definitely we need to create subcommittees or committees to pursue these different positions. I'm going to throw an approach out on the table. I'm not as a motion, but an approach. I would suggest that we keep our committees at a minimal number of people, small number. So it's a good working group. And I would also suggest that 3 people would be an acceptable number, 1 being a Republican, 1 being a Democrat, and 1 being independent, so that we don't have any any disagreement or people complaining about unfair representation as we move forward. And secondly, on the executive director position committee, I will throw my name in the hat to be on that committee, and I will also throw my name in the hat to be the temporary chairperson of the committee until we get a chairperson. So. But I'd like to talk about the approach if people feel that's reasonable.
And by approach, you mean just what you said, what you just.
What I said, yes. The 3-person committee, one Republican, 1 Democrat, 1 independent individual. And I'd say we do this for every committee, not just this one, but this would be the standard that we would move forward with.
Okay, Rhonda, I see your little hand waving. That's working. Good.
I'm trying to decide which one to use on here. My question is, what exactly would the role of the subcommittee be, say, for the executive director position? Is it to narrow down applications? Is it to review them and then bring them to? What exactly would the role be? I mean, are they going to be making a decision as far as narrowing the field down and then just bringing what they feel to us, or what exactly would the role consist of?
Yeah, that was how I envisioned it. Let's say we get 100 applications, then we maybe narrow it down to 10 or 5, whatever we decide. And of that, bring those 5 back to the commission with a recommendation of who we think the top candidate is. That's my understanding. I think the commission's purpose is to filter the information that we got, get it down to a manageable number of people, being the top, what we feel are the top people, and then having that decided by the commission itself on who the executive director would be. That's just my opinion of it.
One more question. In the last meeting, we had it where the Department of State was going to kind of do that. They were going to narrow it down to what they felt was, these ones are the best that meet the most of your criteria. Is that still? Mike, I see you raising your hand.
Go ahead, Mike.
Yes, thank you. So along those lines, we did mention something along those lines, so slightly, it's worth clarifying. So we were not going to be, we the Department of State staff, and I think ultimately what this commission, asked us to do last meeting and what we plan on doing with the resumes that come in. We're not going to be narrowing them down. You may recall I referenced, we could do an initial review, and I think, based on the conversation last week, we will be doing an initial review to sort them into different, categories or buckets, if you will, to say, you received, I don't know, 100 resumes. Of the 150 of them simply don't meet the criteria of what you're asking for. These other 50 do, and then within the, the 50 that do, these are the ones, here are 20 or whatever the number is. Of course, I'm making these numbers up. These 20 meet your preferred standards, and these other ones meet your basic requirements, but not your preferred. And we present all of them to this commission. And then only you all, acting fully as the commission, would have the authority to act, to actually, remove someone or actually make a decision to narrow the list from, again, with the fake numbers I'm using, 100 to 20. And I think along those lines, there's additional questions that I think, Doug, if you're, I think what I understand Doug to be proposing would be an actual formal public committee, a formal committee of this commission that would be charged by this commission to review, maybe the 20 or whatever it is. Again, using still, the Department of State staff would do the initial review, present everything. This commission could then say, hey, Doug and that committee, if you guys were to decide to do that, please review these 20 or please review the 50 that meet the full requirements. And then that would be a decision of this commission, and say, please review those and come back with your recommendation on who we should move forward with. And if this commission asks its committee to do that, then I think the committee could do that, I believe, within a public meeting, where it gets separate. And just to kind of flag, if that's what Doug's talking about, I think that would work within the context of the Open Meetings Act. If, however, someone were to propose having an advisory committee that is intentionally below quorum, that would only be providing review and informal advice, then at that point, that advisory committee would not be able to, and I think Tom had referenced this, but I don't know that he went into full detail here. If it's an advisory committee that's taking on that work of reviewing, that advisory committee would not be able to make a decision and narrow it from 100 or 20 down to 5 or whatever the number you end up coming up with, because they don't have the authority as an informal advisory committee. So again, that's one of the things just to be mindful of. But again, I think what Doug's talking about is actually a committee. And I think ultimately, Doug, to be safe, what you may, if the commission ends up going with the committee to do this work, it could very well be the committee comes back and says, these are our top 5, but here's all 50 of them. So you can see all of them. And, we kind of roughly, you don't have to go through each one, but in broad strokes, this is what we did and why we did it and how we came to these 5 or 10 or whatever the number is that the committee would be recommending to this full commission. I hope that's helpful. Does that work, Rhonda?
Cynthia.
So I was trying to look through my notes, but how many did we decide is a quorum of our group?
9 per the Constitution.
So if we had 9 people on this committee, they could narrow it down.
If you had 9
if you
people on the
created,
committee, they could make the ultimate decision of who to hire.
Oh.
And I don't think that's what we want.
I don't either.
And I have 2 thoughts. Can I?
Go ahead, Mike.
Oh, it's MC. Sorry, Steve. It's MC that was speaking.
You disappeared. Come back.
Oh, MC was speaking, I think, not me.
Oh, okay. Who else? MC?
Yeah. So I want to offer, I like what Doug is saying. I think we do want to try to divide and conquer, so to speak, and try not to use all of our time. And I want to offer that, and I like the approach of 3. And I think that we may come into contact where people maybe of the same party who want to do it and have like qualifications and skills and interest. And so what I don't want to do is limit it to 3. So I want to offer the idea that if we have members of our commission here who do want to be part of the commission, I want to offer that we try to be perceived as balanced, which I think was the intention behind your approach. So I guess I'm just offering that if there were 2 independents and 3 Republicans that wanted to do it, that we try to figure out a way that we as a commission feel comfortable sort of with the optics or with how that's perceived or could be perceived by the public. So I just want to say I agree with your approach, and I want to make sure that we each get the chance to do it if we want it. The second thing I think, I also believe that I think if we as a commission agreed on, let's say, established criteria that the subcommittee would work, we might all feel real good about it. And what I'm imagining, for example, is that we have to define how, like I'm imagining writing samples, right, to try to define the last 3 or 4 or 10 people, and that's just a lot of reading. And so I wouldn't want all of us to have to read it, and I would trust a subcommittee to sort of read it and propose it. But I'm not certain that we actually have agreed on a writing sample to help determine the final, candidates. So what I'm suggesting, perhaps, and I'm not sure this is a motion yet. I want more discussion, but I don't exactly know how I want to do this. But what I'm suggesting is hiring criteria. We have a rough draft that is, I think we've been using the criteria that is in the job description, and we may want to refine or sort of, as a commission, come up with further criteria that helps us feel like we can delegate delegate a subcommittee with the task of bringing back to our whole commission what we want using this criteria that we all as a commission have approved. That's a thought.
Dustin.
So I like what Doug said, and I kind of also like what MC said. However, I do believe that more than 3 people on a commission is overkill, because then we might as well just go to all of us. And one independent, 1 Democrat, and 1 Republic, as far as optics go, in my opinion, that is pretty balanced. And I could add a caveat saying, like, if more than 1 person wants to be on a commission, what I say, if you're on one, you can't be on another one unless no one else really wants to do it. Then at that point, you could take another seat at a commission or on a committee. But opening it up to more than 3 people, I think would be overkill. And then one of each party, and then 1 independent. That would be the balance. And then if we have to have multiple committees for different subcommittees, if you're on one, you can't get on another one unless no one else wants to do it. Then it can be open back up to you. My opinion, my thoughts. So.
Other thoughts from Janice? You have anything for us?
No, I kind of agree. 3 people will probably be plenty. We really don't have any idea right now how many applicants we're going to get. As long as the Secretary of State's office is kind of like putting them in buckets, I think that's a great idea, because it kind of, cuts the workload for that 3. And then the 3 will bring it back. And I'm assuming we're all going to vote on who we pick.
I think that's probably a pretty good assumption, that this commission has to approve and ultimately hire the executive director. I just think that's the way we have to go. Glenn, do you have anything that you want to add?
Well, have we talked about the duties and responsibilities of executive director?
We have a posting of a job description that's been out there, and it's on the website. You can go look. In fact, I looked today on Facebook, and it's posted on Facebook. If you can't find it, let me know and I'll get you a copy, or ask.
No, I've seen it. I was just thinking it was kind of general, but maybe that's the way we want it at this point.
Well, it's what we approved, and it's what's out there to the public.
True. Okay, thank you.
Sally.
Hi, everyone. I just thought I might respond to what I heard as kind of a question from MC about how you might talk about criteria or potentially narrow these applicants, whether it's as a subcommittee or not. And a practice that the Department of State and I believe other state agencies use is supplemental questions for people who are applying, so that you can get a sense of, for example, how many years have you been in a management position, things like that. And so if this commission wanted to think about asking applicants for supplemental materials and or questions, right? Like whether it's a writing sample or, like I said, kind of questions that would allow you to put them into buckets based on experience or other things, even more than their resume and cover letter. That's an approach you could take that's pretty standard in our department.
Yeah, I don't think we're limited, certainly to just what's in the posting in the job position when we're interviewing. However we end up doing that, or however the subcommittee ends up doing that, there's nothing preventing us from asking more questions that we might see. And quite frankly, as we look at applications, or the subcommittee looks at applications, there are going to be things that come up that aren't going to be the same for everybody, but we may look at candidate A and say, well, what about this? And candidate B and say, what about that? So, I mean, it's fluid. Janice.
Do we have a deadline as to when we have to make this decision?
We don't have a hard deadline, but Sally, is there a deadline on applications coming in?
Yeah, so the current closing date for the posting is Monday, October 12th. So if you all will recall, the current kind of schedule that's laid out for this commission has 3 meetings that week, whether it's subcommittee meetings or full meetings, so that you all would have multiple opportunities to review, invite candidates, top candidates for interviews, that kind of thing. So that's the timeline and the meetings that are set out at the moment.
And when I said there's not a hard deadline for us to hire this person, but we do have the deadline of they got to get their application in. And of course, if we didn't find anybody we liked, we could repost.
Yes,
Cynthia,
exactly.
you had your hand up. No, Rhonda.
I'm just full of questions today. So in terms of the subcommittee, are you talking a subcommittee specifically for the executive director position? Or are you talking a subcommittee for all hiring?
Well, I think Doug is talking for the subcommittee for at least initially the ED position, but he also said that it would be kind of the method we would use for other hires. Is that not correct, Doug?
That's correct. I mean, I would see, for example, we're going to end up with a subcommittee for when we're hiring the general counsel and the outside counsel. And there's certain people in this group that have that skill set, that understand the legal environment, and they should be on that committee. So I think each of us have different skills and different backgrounds that can help apply to the different positions that we hire for. And I would suggest that we have a committee for each one of those as we go forward, except maybe legal. Maybe we'll have one committee that'll deal with the general counsel and the outside counsel, because it's the same skill set. So that was kind of my thoughts on that.
MC.
Rhonda, my thoughts on that too are, I see this as right, we're in some ways establishing a potential administration. And I think what I mean is, I think as Doug said, right, if we have people who are interested in, who have experience and also interest, and I say people, what I mean is the commissioners in this, I want our commission to liaise with the staff that we eventually hire in a way that, and because we're only around for a year. It feels like a pretty intense time, and I'm imagining questions and uncertainties and lots of things that are gonna pop up, and the people who read and establish connections and liaise with the commissioners, with our candidates in the beginning, may form a relationship that is very useful as we begin to administrate and answer other questions. And so I'm imagining a subcommittee of people who really care about how our staff can potentially work. So it's in addition to, and it begins at the hiring process, because there's the first, yeah, because we're around for such a short time, it feels like it's a pretty intense time, and to get to know someone and to understand them, and then to help navigate on behalf of the whole commission, but not make decisions on behalf of the whole commission. That's what I want to make sure is being clear. Is I think it's helping, and I don't think it's advisory. I think it's more than advisory, but I don't think we should. I'm hoping that we can each use our time in a place where we as commissioners want to spend more time and go deeper. And I can trust my other commissioners to go deep in their fields, if you will, or in their subcommittees, so that I don't have to know everything about the whole commission, but can know some specific things and understand enough that I can make informed decisions as a commission. I hope that's clear. It feels wordy.
Thank you. Janice, did I see your hand up? No? Okay, anybody else? Just a minute, Doug. Juanita, you're being pretty quiet down there and we can't see you. You have any comments? Okay, Doug.
Yeah, I'd like to put forward a motion that we form a committee for the executive director position. And that committee will consist of 3 individuals, so 1 Republican, 1 Democrat, and 1 independent person.
I second that.
Motion by Doug, and who seconded? Who?
Dustin.
Dustin seconded. Further discussion, Cynthia.
I have a point of inquiry, I guess I'm supposed to say.
Okay.
So I agree with this idea, and it does seem fair to have 1 from each affiliation represented. However, I really feel strongly that I want to be on that committee too. There could be multiple people from the same party that want to take part in that committee. So I don't exactly know how we.
Well, we'll take self nominations as well as other nominations when we get to there. We're not there yet. Any further discussion on the setup, the broad outline of how we're going to set this committee up? MC.
I just want to acknowledge that Erin, before she left, said that she did want to engage in the discussion for subcommittee for ED and just returned. And so I just want to make sure that, yeah, there's some piece here that Erin gets to speak.
Good, thank you. Erin.
Sorry, I think I'm good. I'll just take a look at what I missed while we were gone. I just wanted to be, because I too, like Cynthia, was interested in being on the subcommittee for the ED position.
Okay.
May I suggest, it was MC, sorry, Steve. I was thinking about, what if we just had a straw poll so we could understand what parties each person who is individually interested in might, like, if we have a, let's say, problem that we have to dissolve before we make a formal vote on this motion. I wonder if we could try to just get a straw poll or see who is interested in being on this committee.
Well, we got 3, Erin, Cynthia, and Doug.
I just don't know the party affiliations.
Londa's raising your hand. Are you raising your hand? You're interested? Okay, well, we got a lot of people. Let's figure out if we're going to do it this way, and then let's get nominations and do that number 2. Anthony, you're throwing your hat in the ring?
Yeah, and I have some comments as well.
Okay, go right ahead.
So I agree with having a subcommittee, not only for the executive director, but I think for future hires as well. I think, as we've all kind of stated, it makes sense as we have different areas of expertise that we can bring to the table. However, I'm not sure if we should limit it to 3 people. I think I can already see now we have more than 3 people that want to partake in it. And I don't see why limiting it. I don't see the benefits of limiting it to only 3 people. The perceived benefit is that there is less bias if you only have one person of each party and one independent. But I kind of question that thinking. I think there are plenty of other ways to drastically reduce bias other than having, just people of each party. I don't think it'll introduce much more if you have, two independents versus, one independent and two Democrats. I honestly don't think that matters. There are a lot of ways that you can limit bias. For example, you can remove the names on the applications for the initial rankings. We're not asking the applicants for any political affiliation. And I don't think they are going to volunteer that information to us, on their initial application anyway. My point is, I agree with having the subcommittee. I think that's a good way to go about it to make us more efficient. I just don't know if we should put a hard limit number on it.
Are you making an amendment to the motion? Because the motion is we're going to have 3.
Well, I'm wondering what others' thoughts are on what I just said.
Okay, Glenn.
I question the need to have one Republican, one Democrat, and one independent, because the makeup of the entire commission has already been was it 4 Republicans, 4 Democrats, and 5 independents? So that has already accomplished the task of making it independent. Do we need to get down in the weeds and micromanage and make everything that we do divided up like that?
And I'll
I can tell you,
try to respond.
One of the things that I read in the comments that were mailed in, if I'm not mistaken, I have to go back and look at them, is that there are people out there that are looking at this exact thing. Are we in fact balanced? Do we have a Republican and a Democrat and an independent on things that we're doing, so that one party or the other doesn't take over the commission. So it's out there.
And just as an example, I think we had Cynthia, Rhonda, and Doug who had raised their hands, and maybe Aaron. I don't know if I got you too, Aaron. Is that right? So all
That's
4,
correct.
And they are 4 Republicans. What I mean is, like, I think we, what I'm saying is, like, I
pursuant to our motion, they wouldn't all be on there.
Agreed. And I think that they each have an interest in being on there. And so I'm trying to recognize what Anthony said, that I want to try to see if we can accommodate, right, people who have an interest, and see if there's a way for us to,
If you do that, you do it as a committee of the whole.
Yeah, fair enough. Yeah, so it is a dilemma.
I mean, the idea is you're going to have a smaller committee to spread out the work, because you're not,
Right.
well, that's the idea. You have a smaller committee to spread out the work. So any other, the motion before us is to set up the committee with 3 members, 1, 1, and 1. Is there any further discussion? If not, we're ready to vote. All in favor of, well, I'm going to do a roll call. Sally?
Commissioner, Chairman Lett, if you could actually just pause for a moment. I believe Juanita has comments, but is having a hard time making sure that her phone connection, that she can actually be heard. So Sarah is working with her right now.
We will certainly wait. That is not.
Yeah. Thank you very much. I'll be sure to let you know. Or at least when she's unmuted.
Technology is great when it works, folks.
Looks like Aaron has her hand up.
Yeah, Aaron.
Well, since we're waiting, and as MC pointed out, there's 4 Republicans that are interested in being on the subcommittee, and I will defer. I'm fine with that. But will we be drafting someone from either, the respective parties that have not put forth an interest? So an independent and a Democrat to be on that committee with a Republican.
Well, I'm independent and I'm interested. I'm not sure what Doug is, but he's the one that made the motion in the first place.
Yeah, I'm Republican.
Dustin?
Yeah, I was interested as well, and I am Democrat. And then to further the discussion about people who are interested in committees, that was one of my suggestions. Is once we get to the the makeup of it, if you are part of one committee, then you can't be part of another committee until there's no more interest. And then at that point, you can put your hat in and your name into the hat again to be on another one. Because we're going to have more than one committee or subcommittee throughout the whole process of what we're going to be dealing with. And that would be one way to make sure everyone is indeed included in something.
Sure.
So,
and understand, I mean, we're setting this up right now primarily for the ED, the
right.
attorney, and the public relations. That doesn't mean that this is going to be the committee structure forever and ever.
Right.
So, Cynthia.
Janice also had her hand up, just so you remember.
I just want to say that I don't want to limit someone from being on more than one committee, because we already talked about the next committee, and it might be in that the person who's already been in the committee's wheelhouse. And I don't want to say, well, no, you've already been in one, even though this is like their field and they would have a lot of knowledge. So I don't like the idea of limiting, you being on a committee again.
Well, I think that's a valid point. On the other hand, as stated, we want to certainly spread it around so everybody has an opportunity to input. The other thing that I would hope, and I think that the way that this amendment came about is that whether you identify as a Republican, a Democrat, or an independent, everybody's on the same page that the citizens are to make these decisions so that the politics is taken out of it.
Yeah, I think the reason I mentioned the Republican, Democrat, and Independent was perception. I mean, I take a look at this group and I think we work together well. I don't see any political bias at this point in time, but it's the perception. And that's what we got to manage.
Okay, Sally, where'd you go?
I think Cynthia still had a comment. Sorry, Steve.
Just a minute. Sally,
Yes,
how we doing?
we're working on it.
Okay, Cynthia, there you are.
Okay, so understanding that it is good to divide and conquer. So I would be willing to not be on the committee since there's more than one Republican that wants to, but I want to be clear that how it's going to work. So if the committee whittles it down to a handful for us to consider, does that mean we won't be able to consider any of the others? If we,
No,
we still be able to access their information and bring that forward if we find one that they missed?
no. Everything, all the applications are going to come to us as a committee of the whole. Because if we don't do it that way, then the subcommittee is making a decision which is could be in violation of the Open Meetings Act, though those committee meetings should be open, should be posted and should be open meetings. But my understanding of the way that we're doing it, and Doug may have a different idea, was they're going to kind of say, here's a bucket we think look the best, but here's everybody. And the committee of the whole is going to make an ultimate decision. Doug, your thoughts on that?
I think a lot of it depends on the volume. If we have 100 people, that's 100 resumes to go through for all 13 of us. I don't think we want to do that. I think it really volume drives it. If we only get 20 responses, it's pretty easy to deal with it that way.
I would, Rhonda, go ahead.
I just want to make sure I understood Cynthia's question right. were you asking that the subcommittee say picks 5 people that they feel would be the best, but you reviewed the resumes and you saw a 6th person that you think was the best? Were you asking, is it still possible for that 6th person to be considered, even though you're not on the subcommittee? That is what you were asking. Okay. I just wanted to make, so was that truly answered?
That's my understanding that,
Yeah.
anybody that applies would still be eligible, though probably not going to be picked. Anthony.
So we, as a commission of 13, have the final say in whatever we do, even in whatever the subcommittee brings up. Still, the end decision.
Okay, Juanita, I'm going to unmute you now, okay?
Okay.
You can let's let Juanita speak, and then I'll continue after.
Finish your thought, Anthony, please.
Well, I was just saying that, the us as a commission are going to have the final say. But if the point of the subcommittee is going to be to narrow it down to, however many number of people that the subcommittee then brings to our commission, and then our commission can interview those people, be it 5 or 10 or whatever number that the subcommittee decides. I think it would kind of defeat the purpose of the subcommittee if each person that wasn't on the subcommittee went and tried to bring forth people that the subcommittee already narrowed down. Then we should think about the purpose of this subcommittee in the first place.
Okay, Juanita, comments?
Yes, I don't know where to jump in at, but I know where I left off at when you all were talking about getting executive director and how you were going to choose whoever we're going to get. And I think you're going to go through several applications, whatever. Now, my question is, will all of us, the 13 commissioners, be able to examine the applications or, because I've been kind of left out of the conversation for a while, or will, as I think I'm hearing, you all going to get subcommittees to do it? I personally kind of think that when you have the executive director, that we all should hear or kind of select or get an idea of what the executive director is saying or how he's going to present himself. And then if we're going to do it subcommissions, then go into the subcommissions, if you understand what I'm saying.
Well, kind of where, I'll try to summarize where I think we're at anyway. And that is that however many applications come in, let's pick 20. I think I can work with that larger number. And the idea is the state will kind of look at these and say, here's 10 of these people. They just simply don't meet the qualifications that the commission has laid down. Now they'll still be there, but they'll be segregated to say they don't meet the qualifications,
Right. Mm-hmm.
The next 10 will be presented, and let's just say that they meet the qualifications. So the subcommittee then, as I understand what we've been talking about, will take a look at those 10, well, they'll look at all 20. And they'll take a look at the 10 that meet the qualifications, and then
so just the subcommittee, not the whole 13 of us.
The subcommittee. Then we'll come back to the commission and say, okay, here's 10 that don't meet the qualification. Here's 10 that do, and these 5 we think are the best of the 10. But you, commission, can look at all of them, or we, commission, can look at all of them. If we
Why can't we all take a vote? So would that be too complicated? Is that what you're saying?
No, vote on what?
Well, you said that the subcommittee would choose.
No, I said the
in
subcommittee.
The final analysis.
My understanding is the subcommittee is going to look them over and going
look them over,
kind of rank them and say, here's what we think are the best possibilities. Then the commission's going to vote. And if someone is outside of their recommendation, we can still look at them.
Just like a sorting kind of a thing, like an initial look to sort things out.
I just Yeah, I just wonder why we all couldn't just see it on the first get, hear it, or hear them read at the first get, and then still let the subcommittee, if they choose to go on and select.
Well, you can make that as an amendment. The motion before us that we're about to vote on is that there would be 3 members of the subcommittee with one, and that they would have the obligation to review the applicants and bring back a breakdown. Mike, you're going to enlighten us.
Yeah, thank you. So it's not a legal point, but just more of a practical point that crossed my mind. I appreciate the conversation, the back and forth. I noted, Doug, I think I heard you say in response to a different question someone else had raised, that a lot of this really depends on how many applicants you get. And I just know that this application has been up for, I think, 3 days. This may be the 4th day that it's been posted. And so as a practical matter, there may very well be other committees that this commission wants to create, but that if in fact it really is a question, as Doug said, of volume of applicants, you'll know that as soon as it comes in, and that could also just be an option that once all the responses come in, we've already been directed by you all to do an initial sorting into these are all the ones that are actually responsive to what you asked for by our read. These are all of them, but here are the different categories, and then at that point, maybe that would address Juanita's concern. Maybe it actually works for Doug, maybe it doesn't. So should have offered that as a practical perspective. I think there nonetheless are other sorts of committees that, even if you created this committee right now, you still got time before this committee is able to do anything, because we literally have no resumes that have come in yet, and the deadline hasn't actually been met yet. So just kind of wanted to offer that as a practical perspective that, if you acted now with question marks of how many are actually going to respond, it's just that, it's question marks, and this committee doesn't actually have anything they could do yet.
Well, and just to follow up on that, Mike and Doug and everybody else, if it comes in that we've got 3, 4, 5, 6 applications, there really isn't a need for a subcommittee. We're going to look at all of them. In my mind, now the commission can certainly choose to do whatever it wants to do, but
I think there is a need for a subcommittee in that instance as well. Because one of the purposes of the subcommittees come back with recommendations, and to justify their recommendation as well.
Yeah.
Because of those 6, 2 of them may not meet the qualifications, but we need to look at them.
I understand that. I just thought maybe that the whole commission can hear and see what the applications read, and then the subcommittee can do whatever they want to do.
I think Steve mentioned everybody's going to get a copy of every one of the resumes to be able to look at. Is that not true?
How are we going to get those copies?
It'll be emailed to you.
Yeah.
Oh, okay. Because I didn't get a copy of something that you guys had this morning. So I guess it's my computer that's kind of on the.
Yeah. So you'll have access to all the data.
MC.
And, oh, sorry, Chairman, I just want to say, Juanita, we will work with you to make sure that you get them. We have a couple of ideas on how to make sure you get all the materials. So don't worry about that. We at the Department of State can certainly make sure you all get a copy of all of the applicants.
Okay.
MC.
So would you, I think we're voting specifically, but the motion that's on the table, Steve, if you could restate it, is specifically for forming a subcommittee with 3 members, as stated, from each party or non-party, and specifically for the executive director position. Is that accurate? It's not just a general subcommittee structure with 3 people?
My understanding, and Doug can correct me if I'm wrong, is that this would be a proposal for the subcommittee for the ED, the attorney, and the public relations. Is that right, Doug?
That's correct. I think we should stay consistent as we move forward.
Okay, so
that'd be the top 3 hires that we're making. shortly.
Okay.
Okay,
it's a
so
general
there's
hire.
3 departments.
I'm sorry,
Three
Juanita, go
positions.
ahead.
I was lost on so many things when my computer went out. But are you saying also, besides the executive director, we're going to also pick a public relations committee and what other committee?
Attorney, general counsel,
Okay. And each one of those will have what, 3 committees?
3 members
3 members per person,
per committee.
per committee.
So-
Okay. Have you chosen the committees yet?
No, that's what we're voting on.
And Juanita, to clarify, I think the proposal right now, I think, is not to have 3 separate committees for those 3 separate positions, but to have one
Okay,
committee
good.
that would
For
do
those 3.
these 3 positions. I think I got that right. Is that?
I
That's
understand it
I-
as 3 separate committees.
3
Oh,
separate
3
Yeah.
separate. Okay.
Oh,
Yeah.
really?
Glad we're
Oh,
talking
it-
about it.
3
That way
committees.
we get more people involved.
The structure would
Okay.
be 3 people, 1, 1, and 1.
Okay, well, I know you all said something about public relations, and that's what my skills are in. So I was interested in that part.
That you have not missed out.
Okay, great.
Okay.
Thank you, Steve.
Any further? No problem. Any further conversation? Are we ready to vote? Sally, help us take a roll call, please. The motion
Absolutely.
is that we form a subcommittee, that we form, in fact, 3 subcommittees of 3 members each, 1 Republican, 1 Independent, 1 Democrat, for the purpose of looking at the applications for executive director, for general counsel, and for public relations. Sally, call the roll, please. All in favor will acknowledge by saying aye.
Thank you, Chair. I'll go in alphabetical order by first name. Anthony Eade.
Aye.
Brittany Kellum is currently absent. Cynthia Orton.
Aye.
Doug Clark.
Aye.
Dustin Witches.
Aye.
Aaron Wagner.
Aye.
Glenn Shaw.
Aye.
Janice Villette.
Aye.
Juanita Curry.
Aye.
MC Rothorn.
Aye.
Rhonda Lang.
Aye.
Richard Weiss.
Aye.
Steve Lett.
Aye.
That is a 12 commissioner aye vote.
Okay, that passes. So we can form the executive director committee because that's all that's out there right now. Unless, and I would open the floor for self-nominations or nominations by anybody that wants to be on the executive director subcommittee. Requires 1 Republican, 1 Democrat, and 1 non-disclosed person.
May I move to ask a question right now, Steve?
Sure, absolutely.
Okay. When we select the 3 different subcommittees, wouldn't it be pertinent if all of us would come together and hear what each one of them are doing and saying or whatever? I mean, to be informed on everything that's going on, or is it just the subcommittees will just present something after they do it, or they're going to let us know what they're doing? Even the general counsel or the public relations, wouldn't we share everything, or the committee is just going to do it and then bring it to the commissioners? How are you going to do that?
I don't know that I understand where you're coming from.
Okay, what what I'm saying is the three committees that we're getting ready to vote on, will the first thing that they do, will they just examine the material themselves, or are they going to bring it to the 13 of us, and then the three make the different committees make their own, choose to make their own vote on it, which would be good but after we've all heard it
Well,
or seen
Open
it
it up for
or
discussion.
read some of the applications.
Discussion on those comments? Anybody?
I think I heard Rhonda, excuse me, not Rhonda, sorry, Juanita, I think I heard your question as, will we all get to vote and will we all get to see the material that the subcommittee is deliberating on? Did I understand your question correctly?
Not necessarily all vote, but say for instance that you all choose a executive director committee. Will the committee, before they decide to take the final vote on the executive director, will they present it to the total body of the commissioners?
Well,
yes.
let me stop you there. The commission will take the final vote on who we hire.
Okay.
The
Okay, that's
subcommittee will only look at whatever comes in and then come back to us with whatever they see and whatever their recommendations are. But we, as the
Okay.
commission, will make the hiring decision by vote.
And so the committee will let the commissioners know what you have read, what you have obtained, and your suggestions, and then we can vote. Is that what it is?
That's my understanding, yes.
Okay. Just wanted to get
Okay.
some clarity.
Nominations for the committee for the ED.
I'll do it on the Democratic side. And that would be Dustin.
I'll nominate Rhonda.
I'll nominate myself. This is Doug, Republican, and I'll also volunteer to be the acting chair until we vote on a chair.
Rhonda is Republican, right?
Yes, yes.
Okay. And Doug.
Correct.
So that's two Republicans.
Rhonda.
Can I also nominate Cynthia? I don't want anybody to back out of a position that they were interested in. I want everybody to have a fair chance. So if we could put Cynthia's name on there, and in all honesty, Erin too, because she did raise her hand at the beginning. So can I nominate two? I want it to be fair to everybody, and they were interested. So I want them both to be considered also.
So Cynthia, you've been nominated and you're Republican. Okay, and Erin was interested and she's Republican, right?
I'm going to defer to the other three that are on the list.
So you're declining to be nominated.
That's correct.
All right.
I will.
Cynthia?
I will do the same.
Decline to be nominated?
Yes.
So we're crossing you off. So that leaves Rhonda and Doug. And you two can arm wrestle for it.
May I ask a question?
I think it should go to a vote.
Question. Go right ahead.
Yes, the people that are selected for the subcommittee for the executive director, they would need knowledge in this attorney, right? They need more formal knowledge, wouldn't they?
I think Doug's got a long history in management. Certainly we can have a campaign speech right now.
No, I'm only asking a question. So to me, it would be great if they have that kind of background. So that's great.
We need a neutral. Somebody wanted to volunteer. Janice. Who else?
I think Anthony already said that he would do it, so I'll nominate him.
Thank you, Janice. I'll accept.
Okay, anyone else for neutral? Anyone else for Democrat? That leaves a runoff between Rhonda and Doug. We have to have a roll call. Sally, will you please call the roll? And we'll start with Rhonda. All those who would vote to have Rhonda on as the Republican member of the ED committee.
Steve, before we do that, maybe each of them would like to, say something about why they should be chosen.
Yeah.
Well, I suggested a campaign speech, but go right ahead. Doug.
Yeah, sounds great.
Okay, yeah, what I can bring to the table on this committee, as well as any other committee, is my almost 40 years of management experience, dealing with people and hiring people, and firing people as well. So I feel I have a good background in trying to identify people that can accomplish a job, and I've got the experience to back that up. So.
Okay, I'm sorry. As for me, I don't have 40 years of experience in management. However, I have held management positions where I've gone through the hiring and firing process myself, interviewed applicants. I feel like what I could bring, I have a strong gut instinct when it comes to people, and I can look beyond people and almost like, I don't know if you'd call it their souls or whatever, but I just have a good instinct about people and who's a good match for positions. And I think I would do a good job.
All right, all of those who would favor Rhonda to be on the committee, Sally, call the roll, please.
Chairman, could I ask that I call each person's name and then they vote for either Doug or Rhonda?
Certainly.
Does that work? Okay.
Sure. We'll find out if it works.
And Sally, before you do that.
Yes, go ahead, Juanita.
I'm sorry. Before you do that, I guess I lost so much time trying to put my thing together. But the executive director that we're selecting, the applicant, he is one of what, an attorney? Is that what we're selecting for? People that's going to work with that? Yeah.
The executive director. The executive director is the position that you all voted on and approved last week, the first one, which is posted online at redistrictingmichigan.org right now. It's a sort of the language you all voted on is, management and administrator type role.
Oh, okay.
Doesn't mean he might not be an attorney, but it's not a requirement.
Oh, okay.
Okay.
Okay, so thank you, Chairman. I'm going to go in reverse alphabetical order by first name to call on this, which means first person is Steve Lett.
Rhonda.
Richard Weiss.
Doug.
Rhonda Lang.
Rhonda.
MC Rothorn.
Rhonda.
Juanita Curry.
I almost said myself, but Rhonda.
Janice Villette.
Rhonda.
Glenn Shaw.
Doug.
Aaron Wagner.
Doug.
Dustin Witches.
I'm going to go with Rhonda.
Doug Clark.
Doug.
Cynthia Orton.
Rhonda.
And Brittany is not present. Anthony Eade.
This is a hard choice. I'm going to say Rhonda.
By a vote of 8-4, Rhonda has been selected.
Okay, the committee then is Rhonda, Anthony, and Dustin.
Do we select a chair for the committee now, or do you guys think the subcommittee should decide amongst themselves who's the chair of?
We should have an acting chair at the moment, and then in your first meeting, you should elect the permanent chair.
Is it my?
That's fine.
How formal is this going to be? I mean, if we're just looking through things, I don't honestly think a chair is necessary, personally.
Well, you need somebody that's going to set up the work with Sally and the staff to get the meeting notices, etc.
Never mind.
So if you want to have an acting chair now, that's not a bad idea. So somebody's working with the staff to figure out where you guys are going to be, because you're going to have open meetings and who's going to get all the work, etc., etc. So any volunteers for temporary chair? Anthony, is that good with Rhonda and Dustin?
It's fine by me.
I'm good with Anthony.
Okay.
Anthony.
You and Anthony.
Yep.
All right.
Hey, Steve?
Yes.
Let me volunteer to put together a chart of some type that we can begin to track who's on which committees. And then I'll forward that over for review in the next meeting. Just an administrative thing. So goes back to Dustin's comment. We want to make sure everybody's participating in
Sure.
the different committees. So we need to track that somehow. And I'll be able, I can put something together and we can look at it next meeting.
Okay, that's reasonable. You're going to bring it to the next meeting, or you're going to send it out previous to
I'll send it to Sally and have it distributed as soon as I get it done.
Okay, that's good, because that's due to our amendment charter, we need to have everything out in the public, so.
Correct, yeah.
Okay, now, the other two subcommittees that we would be looking at, and I would suggest that we may want to push those off until our next meeting, since we haven't posted those yet. So unless there's some burning desire to have those formed right now, I would like to move to the next item on the agenda, which is thank you notes. Glenn, you raise your hand? No? Adjusting your hat. Okay. All right. Thank you notes. We had a thank you note presented to us. Was that MC that did that?
Yes, with a lot of support from the Secretary of State.
Okay, you're on, MC.
We drafted we used the logo. I think it's excellent. Thank you, Kathleen. And if you've all read it, I think I'm just going to move that this is what we've come up with. I think it's formal language. I think it's safe formal language, and I think it gets to the point. And it has a sort of the most. I think the thing that I would offer is that we have a logo that is out there that we're potentially associating ourselves with. That I think we want to be conscious of, and I think it's great. So I guess what I'm suggesting is I would suggest that we go with this, and there's I think 2 drafts for a reason. One is to the academic presenters. I believe that's what we're looking at currently. Is that right, Kathleen? You go to the, and this is to the commissioners, right? So different language for the academic presenters than to the commissioners.
Yeah, I looked at these and I had a couple of comments, suggestions. I'm not against either one of these. Is in my mind a matter of style, but in the first paragraph we say, starting at the second sentence, taking time to meet with us during our first convening on September 17th. Well, there's not going to be a second or a third convening. So my suggestion would be during our convening meeting on September 17th or 18th. And secondly, in the third paragraph, we offer our thanks to you and your fellow panelists. My thought there was that we're sending this letter to each one of them individually. And so my suggestion is we offer our thanks to you for taking the time to meet. Like I say, style more than anything.
Yeah, and it's more personal. I appreciate that. Good thought.
And if we want to go to the next one, it's kind of the same thing on the California and Arizona. Make it the convening meeting. And then in the second paragraph, we talk about information from experts like you. You know, they're experts by way of on-the-job training. My suggestion there was important information from those who have gone before us, which would be the commissioners from California and Arizona. Like I say, just my own personal style.
I like it. I think it makes it more personal. I wasn't sure that the tone between formal and yeah. So I appreciate your comments, and I would accept them.
Anybody else? I thought, number one, I thought they were very good. Like I say, these I did not have any questions. I think we should send them, and we kind of got a template as people come in that we can then use, or somebody can have a brainstorm and come up with another one each time. Then we don't have to use the same one every time. Any comments? Juanita, you got any comments?
Yes. These thank you notes and the logos and stuff that we're using, is this going to be a template we're going to have made for our department period, for the commissioners period? And what I think that probably would fall under public relations. Are you ready to send your thank you notes already, or are we designing them, or are we getting someone to design them? Is that what we're doing?
I think we're designing them right now, Juanita, and I suppose because we don't have a public relations person yet and our staff person, what we're doing is trying to be timely and thank the people who volunteered to help us and keep us running, or get us up and running. And I suppose we're trying not to wait until we do have staff to do it, so that we can continue to call on their experience and expertise, and I think as a courtesy, I think that's what we talked about last time we met, and we approved to do this. So we are drafting and I think trying to approve the thank you letters right now with what is in front of you on the screen that you may not be able to see. It occurs to me, sorry.
I can't see it at all.
Okay.
But also, I think that probably a box of nuts or some candy or something sent with the thank you note would be appropriate.
We sent some M&Ms. Aaron.
Just in looking at this, where it says, I hope you and yours are well, and then we go into a we the commissioners. Don't we want to change that to either we hope you and yours are well, or I would think would have to change the wording to remain, as a commission and not an individual there. And were we changing it to be more personalized as well on the, I think maybe you did that already, Sarah, or just doing that. Where we had asked or said, we want to thank you and your fellow panelists, were we going to personalize it there as well on the second letter?
Yes,
I don't think
that was my suggestion, that we would take out "and your fellow panelists." We would remove that. That was my suggestion.
And one other suggestion would be to not say "hope you and yours are well," because this is more of a this is not a family like thank you. It's more or less to that commission and the people that worked with them. So I like the second one.
This is coming from us as commissioners, Juanita. So we
I
are
know.
trying to draft
I
one.
absolutely know that.
Okay. So what I think
But I'm
you
just
said.
saying the reading on it. I just didn't think that to send them something saying, I hope you and yours are well, but just to be very considerate in saying we thank them for their professionalism or their expertise, and we greatly appreciate it or something. But
Would it be helpful?
I agree. I don't think we need to say, we hope you and yours are well.
Okay.
What do other people think?
Well, and I'm just aware that Juanita might benefit from actually us reading it because she hasn't been able to see it ahead of time and she can't see it now. And so I'm wondering if we read the whole
I
letter.
can hear how it reads.
Oh, so there's like 6 paragraphs.
6
It's a whole
paragraphs for a
Yeah,
thank
it's
you
a
letter?
whole letter. Yes, it's a whole letter.
That's almost too much for a thank you letter.
That's
You
what
know,
I thought it might be.
I did. I'm sorry. I studied public relations. Well, you know, and so just, you know, I've sent them many thank you letters to all kind of people. So
I don't
I
see
think
what
we
the
have
harm.
time to read it out loud.
I
Yeah,
can
that would be
read it. I
good.
can, well, listen, MC, you read it. It's your letter.
Okay, it is. So this is to the California and Arizona commissioners. I'll read that one first. Dear Arizona commissioners, we hope you and yours are well. We, the commissioners of Michigan's Independent Citizens Redistricting Commission, would like to extend to you our most sincere gratitude for taking time to meet with us during our convening on September 17th. As commissioners, we are excited and humbled to be responsible for redistricting in our state. Our success depends on our ability to learn important information from those who have come before us. We offer our thanks to you and for taking the time to meet and engage with us. The presentation and material you offered to us was clear, thoughtful, and exceptional in quality. You have done us and the state of Michigan a great service. Sharing your experience and lessons learned as a former commissioner in California or Arizona provided us with key insights on what to expect in our new roles, both personally and professionally. This insight was exceedingly valuable to each of us, and the wisdom shared will aid us tremendously as we embark upon our journey as redistricting commissioners. We also extend our appreciation for your generous offer to continue providing information and guidance to us on future occasions, should we need it. Thank you again for all your efforts. We look forward to future meetings and conversations with gratitude, the Michigan Independent Citizens Redistricting Commission. And that's one letter, Juanita. There's another one that has a little bit different language, but it's basically the same idea. Does that feel like it's too long to you, or does it change any comments you had before?
Yes, I think it's too long because you're reiterating somewhat of the same words with different words. And so that's what makes it too long.
Okay.
I think that we get to the point with gratitude and it sounded good, but it just sounded kind of repetitious in what you were saying over and over and over.
Right. So this is also based on, oh, you know what? There was somebody else trying to speak. I can't see my whole screen.
Aaron.
Whoever it was.
I just wanted to say, we might want to change those who have come before us to those who have gone before us.
I disagree with that. Those who have come before us, because they did come before us.
Correct, except that, okay.
That's not what I was getting at, but when I was making the change, I put in gone. They had done this job before, not that they showed up in front of us.
Ah, there you go.
I think you all need to study a little bit more what you're going to say.
So would you recommend, Juanita, that we, it seems like it
Shorten
might be, yes, and it seems like it's important to you. I don't think we waste too much time if we table this and allow Juanita to actually look at it and as a commissioner sort of make her suggestions. If you're willing to do that, Juanita, would you accept that and try to help us craft it? It seems like I know that we've had a number of back and forth right now, but because you're not able to see it, I'm wondering if useful for us to continue trying to, wordsmith and make it a decision without you being able to see it and potentially,
Yeah.
Yeah.
Yeah, I can't see it, so but I know it's a little bit long for a
Right.
thank you letter.
And
Well,
therefore you would,
The suggestion, Juanita, is that we make sure that you get both of these and bring back to the next meeting your revisions and see if we like them. Would you do
Okay,
that?
that sounds great. Sure.
Okay. Is that good
I
with
would-
everybody?
Yeah, but I did want to add an idea here real fast at the bottom. And that is we add our names and signatures to it.
Well, we can consider that.
So, but
It
I
looks
can
like-
move to table this until after Juanita has a chance to take a look and offer her suggestions as well with her professional expertise in the matter.
There, a second.
Second.
Okay, it's been moved and seconded that we table this to allow Juanita to look at these and bring back suggestions for the thank you letters to the next meeting. All in favor, say aye.
Aye.
I,
All opposed, the same sign. Passes. Okay, we are at a order of the day, which is a 5-minute break, and it is 11:46, so we'll be back at 11:51.
Just wanted to thank MC for putting it together.
Oh, you're fine.
He was really bad at this kind of stuff. I do appreciate it.
Yeah, very good job.
you're welcome.
So are we gone?
So Anita, would you like me to place you on mute for the remainder of the break?
Yeah, I'm gonna see if I can try to get this computer working. It really is stubbing me, or whatever that word is right now.
About time. Nice.
Okay, I think everybody is back. Juanita, are you back?
Yes, I'm here.
Okay, the reason I ask is you're at the bottom of my screen and I can't even see whether you're here or not. Okay, we are at the code of conduct, which you received. And just so everybody knows, it's almost noon and we only have to 1 o'clock because the translation folks are done at 1. So we're done at 1. Code of conduct. Juanita did not get a copy of this code of conduct, I'm assuming. Is that correct, Juanita?
No, I didn't.
Okay. Makes it a little bit difficult, but we can take a look at it and have some discussion, but then we will defer any adoption until you have had an opportunity to look at it, and then we will either pass it or not pass it. So having that, it's open for discussion. Any comments, additions, corrections, edits by anybody?
Yes.
Rhonda, I saw your hand waving first.
They actually have it on screen highlighted, the one I have questions on. I would kind of want further information on it. Are they saying lobbying as far as putting money towards a specific ballot? Is this particular thing saying that we cannot support any legislative bills or measures whatsoever? And what is their definition of support?
Right.
I'm not trying to overread it. I just want to be clear on what this says. And I have my reasons. That's why I want clarification on it. It's letter D.
Mike, are you around?
Steve, I have a point of clarification. I just want to offer to Juanita that in the binder that was given to each of us, we are on page 36 of the orientation materials that has the same code of conduct. So you potentially could look at it. It's printed and it was sent to us for that very first convening we had. That's all. Sorry.
Thanks. MC, I think I looked at it, read it the other week, a few days ago.
And hi, everyone. I just wanted to hop in here really quickly. Sorry about the technical difficulties on our end, but I don't believe that's what's shown on the screen right now is what you all received. So we're going to take that down and pull up the PDF that you all received that's also posted on our website. And, you know, I want to clarify for the public watching that all commissioners receive the materials that we discuss in these meetings the night before, and that any of you watching can go to redistrictingmichigan.org and you can see all of those same documents. So I don't want it to appear that there are materials or information that the commission is talking about in this meeting that you all haven't had the opportunity in the public to see as well. So just wanted to make those notes, and we will get the correct code of conduct copy pulled up as soon as we can. Thanks, everybody.
Thank you.
So is Mike available?
Mike Brady.
I am. Camera's not working at the moment, but
no wonder you look so good.
Bless you. So I actually, on this particular topic, would defer to Sally. I was not involved in the drafting of this particular document. I think it came from, again, my understanding, Sally can confirm, I believe it came from other materials that have been pulled from other, similar kinds of commissions.
Yes, that actually number D specifically came from the California Code of Conduct. It's almost the exact same words. So.
Rhonda, I have a question for you where it says commissioners shall not support or oppose specific ballot measures and or legislative bills prior to November 1st, 2021. does that mean to you that if something were to come up for a vote, you couldn't vote for it in a general election? Or does that mean to you that you can't have your face show up on a billboard saying that you want this enacted? I
Let,
guess there's a difference there.
right. Let me clarify what I'm thinking and how I'm reading this. There's some things that are near and dear to my heart. I'm a veteran. I read a story where there was a bill in another state that increased benefits to veterans. That would be a bill that I would truly be behind. It's not something that I would put money behind. So that's where I'm trying to say, if somebody came up to me and said, well, what is your opinion on, do you support this bill? Am I, as still a citizen, even though I'm a commissioner, am I just supposed to stand mute and not give my opinion, I guess, is what I'm saying. Are we still allowed to support specific bills, not monetarily? And also I ask this because being a broker, in order to be on our MLS, we are required to be members of the Association of Realtors, national and local, and they do have an RPAC, which when our dues come out, they try and take out for the RPAC. Just so you know, I don't contribute because I have my own personal beliefs as far as things like that go. But I just want to make sure that either way, it's defined on what, I guess, what is meant by supporting or opposing a ballot or a measure or a bill or whatever. What is it saying? Is it saying, to put it in layman terms, is it saying, you know, just keep your mouth shut on what you do or don't support? I mean, I don't know how to word it. Do you guys understand what I'm trying to say here?
Well, my take on it would be that, and I said the billboard, but that's being somewhat facetious, but not much, would be that you certainly obviously can have your own opinions as to, say, your VA bill or whatever it is, but that the commissioners would not take a public stance on opposing or supporting specific ballot measures or legislative prior to the time that we have this done. Quite frankly, if these bills don't come up, typically they don't come up at least anymore, as bipartisan bills. They come up either from Republicans or Democrats, and if we as individuals start supporting them publicly, then it diminishes our nonpartisanship, in my opinion. So I don't know if that helps you. Clearly, you can't go out and lobby, period.
Right. But I mean, where does the line, is there a line between, your citizen, your private citizen, what you believe in, and then the commission with still being obviously they know who's Republican, who's independent, who's Democrat on the commission. So I guess, is there a line there? Is there a line there? Like, if somebody, not speaking as a commissioner, if somebody came up to me, a friend, a neighbor, whatever, what are your thoughts on this? What do you think of this? And they're talking to me as a private citizen, not as a commissioner, as a neighbor, friend, what have you. I still have that right to say, hey, I support this or I don't. I'm very by the book, matter of fact. So that's why I'm asking.
Well, I think you certainly, if you're talking to your neighbor, there's nothing that says in the amendment or anywhere else, or the requirements when we made an application as to what you could or couldn't do. So you could, I would think you would be on safe ground doing that. Again, if you're out there being interviewed by I don't know who, WJR or somebody, or CBS or NBC expressing an opinion, I think that's a step too far. You've crossed the line. And when you say you don't give up your personal rights, well, you do. In order to be on this commission, you gave up the right to run for office, and you gave up a lot of stuff, and you gave it up for 10 years.
Correct.
So I think you got to use you know, you don't have to go in, you don't have to become a hermit, but you certainly have to be careful of what you're doing. Glenn?
Yeah, where, may I wear a political pin? May I have a bumper sticker on my car?
My personal opinion is I'd stay away from it, but I don't think there's anything that says you can't. I mean, the whole idea behind this commission is to get politics out of it.
Right, and I'll
Anything,
offer,
anything that we do, that this commission does that shows more politics than we already show, which is we've declared who we are and what party that we lean for. I guess my hope would be we wouldn't do that. But I don't think there's anything, I haven't read anything says we can't.
Steve, it's MC, can I offer one other piece?
Sure.
We can anticipate as a commission having legal responses to challenges. And I think if we create more reason for the people to think that we may be partisan because of a bumper sticker, because of an action, what I think we want to do is be careful with the budget that we've been given and not invite more legal action that says, hey, you're like this person is clearly partisan. So I think we're trying to just recognize that if with this code of conduct, we might be helping ourselves, stick to something that where we're using government funds and citizens' tax dollars wisely and not inviting more legal challenge. That's one of the takes I have. That's how I'm kind of reading this.
That help you, Rhonda, at all?
I got a good way to think about it. When in doubt, don't do it. It's the easiest way to keep yourself out of any kind of conundrum.
Well, you know, typically that's right, but I understand Rhonda's conundrum.
Yeah,
She's
so do I.
has strong beliefs and wants to express those in the right circumstance. But I also feel that, you know, we have as a commission a responsibility to be as fair and equitable as possible in all cases. I would, I guess I go back, I would like to table this until the next meeting to allow Juanita to get a copy of what we put up and go from there.
I think I have some kind of way. I see the letter that MC wrote. Is that MC right? The letter to the academic presenters?
Yes,
Okay, I'm looking at that letter, and then I think I can pull up. It's just this computer had me go around the bush, but I imagine I can pull up these few letters and stuff and look at them after we probably leave, so I can continue to hear you guys.
Okay.
And concentrate on what you all are saying. Excuse me.
Are there any other comments or questions or edits or discussion regarding?
I have one.
Mike.
Sorry, this is Mike. Again, camera's not working at the moment. Hopefully I can get that back together. One of the things, I appreciate the question from Rhonda and just some of the back and forth, is though I didn't draft this, and I understand, you know, where it came from in California, one of the things that crosses my mind is just thinking about maybe the question from Glenn, you know, what about, you know, a bumper sticker or someone indicating how you, you know, are going to vote on something. Notably, paragraph D doesn't talk about how you're going to vote for candidates. It only talks about support or opposition to specific ballot measures and or legislative bills. And so I'm not saying that that's good or bad, but I just point out that some of you, I think I heard, were raising kind of perhaps even a preference for something that would be more restrictive than what's actually in D. And then some of you may have been raising questions and concerns about whether D is in fact too restrictive by itself. And so I just want to flag for like what D actually says versus what it doesn't say. And one of the things that also crossed my mind is just in terms of the Again, there's obviously an election going on. There'll be other, there may be other elections in smaller elections in individual communities next year that maybe some of you will be involved in or not for individual races. And so in that regard, D doesn't seem to prohibit you at all from voicing, your support or opposition to an individual who's running for a specific office. And so whether that's something that you feel strongly about or not, just be clear there. The other thing that crossed my mind is that California, I'm not sure their full structure, but this says that commissioners shall not support or oppose, ballot measures is one thing, but legislative bills prior to November 1st, 2021, and it specifically prohibits lobbying under the IRS definition. And I'm just wondering actually whether, frankly, that may be in conflict with the language that's in the Michigan Constitution that allows you to go to the legislature and ask them for more money. And if the legislature were to adopt more money, that itself would actually be a legislative bill necessarily. It'd be an appropriation from the legislature to this commission if you found that you needed more for attorneys or otherwise. Separately, just kind of, so other thoughts along those lines, and whether, you're also allowed to sue the legislature if they don't give you what you need, and that's in the Constitution as well. Paragraph D doesn't speak to that. That's totally silent there. So I almost wonder if, for those of you who have concerns about just the perception of politics and all of that, whether D should be rewritten, again, by you all if you decide to perhaps allow you to, collectively work on legislative issues that are at least related to this commission, but then also perhaps address some of the other concerns that are not actually covered by D. So I think D may be both too inclusive, like over and under inclusive at the same time. And I think that's probably just a difference between Michigan and California's structure.
Well, the other thing, Mike, that California would have is they have ballot measures. They govern by ballot measures in California. So it's a lot different. They probably got 200 ballot measures coming up in November. At any rate, that's not a bad idea. Rhonda, would you be willing to take a look at D and bring us back some language?
I'll do my best.
Thank you.
Mm-hmm.
One of the things that I had put down for D, where it says lobbying under IRS definitions, I don't know if Michigan's different, but I added in there and/or Michigan definitions. Maybe Mike knows if Michigan has more restrictive definitions than the IRS is to lobbyists.
There is the Michigan Lobby Registration Act, which does govern that. I'm not sure that I would necessarily describe as being more restrictive, but there's certainly a distinct set of rules there.
Okay, so that would be my contribution. Unless there are further questions, we will table this and have Rhonda bring that back the next meeting. Communications director position. We have a proposed draft of the posting. And we, Juanita, are you able to find that so you can look at it?
I'm on, right now, I'm looking at, I've only found MC's 2 letters. Trying to see. I will find it before the day is up. I haven't found it.
Okay.
Can you hear me?
Who said, can you hear me?
I did.
Oh, yeah, we can hear you fine. Yes.
Okay.
All right. Does anybody have any comments, edits, corrections, additions? Kind of along the same lines that we looked at for the ED. Not the same job description, but kind of the same setup.
I have a question, Steve.
Go right ahead, Doug.
Yeah, the top line says draft communications and outreach director job posting. To me, I see communications and outreach as two separate things. And so it may be a function of how we define this job. I see outreach, let me tell you how I see outreach and how I see communication. I see communications as public relations, such as, media, sending things out to the media, communicating to the media and so forth. I see outreach as an individual that would, or a group that would be responsible for collecting our data, both email, text, public sessions, summarizing the data, presenting the data, maybe a database of outreach comments, and compiling public input. So I looked at those as two different things. I don't know how others perceive those.
Anybody else have a comment? Juanita?
Yeah, I think that is kind of our problem, is that when we're writing letters, we're putting two kind of different words to things, and it's kind of complicating. Our letters should stick to, even our postings should stick to simple, right to the point information of what we want, and just keep it simple and intelligent, and professional.
Glenn?
I appreciate Doug's comment that communications and outreach are two different things, but why can't we make both of those things the responsibility of this person?
I would say skill set would be the biggest reason.
I think we can try to get
You
somebody.
mean it's too broad, too much for one person, or too broad of a responsibility?
That was I looked at it as two separate functions, job functions, and maybe we can combine them. But to me, the whole job posting description was written from the standpoint of a communications director. And I look at outreach as a little different.
It is different. And we should just keep it as what you first intended for it to say.
We can go either way. I don't care. We just got to make sure that we're defining it properly.
So when you're defining it properly, we're looking for what? We're looking for an executive director. And then the things that we want him to have in his resume, we should list them. And if he comes very, very close to it, that should be sufficient, or to us, or whatever. Or if he goes over it, that would be sufficient.
Correct.
You got to probably put some things in there to let him know what we're looking for. So if we describe what we're looking for and just keep it simple, and then he can help put the description, whoever it is that's looking for a job.
How do you define outreach?
Are you talking to me?
Yes.
Well, we're looking for the executive director. You're looking for an outreach person or a what? I heard two names.
Well, I see it as two functions: public relations, which is communications, and outreach, which is dealing with collecting the data from all the different sources.
Communication.
We're going to get comments from email. We're going to get them from text. We're getting them now from public comments. We're going to get them in the meetings. I see that as an outreach type of function, where somebody would collect that data, summarize it, and present it. If you go back to what the California people dealt with, they had all this input from the field, from the citizens, but no way to really sort through it and filter through it to use it. And I look at that as outreach. I may be a little off base on this whole thing, but that was my opinion.
Cynthia?
So since they've done it. Oh, okay. Got it.
Cynthia?
I just wanted to clarify, because Juanita was saying the executive director, but we're talking about a different position now. So we're talking about communications person and or outreach director. I just wanted to clarify that we're talking about this one.
That's correct. We're talking about communications and outreach director job posting.
Okay, and I know that, but I'm just saying that when whatever you're looking for, just simplify it and put that in there, exactly what you want. And if we want the outreach person and we want a communicator, communications, right? Outreach and what?
Communications.
I'm not in communications. Okay,
Yeah.
so then we should kind of, if you're going to use both the words, kind of describe the communications person and what you want and the outreach of what you want. Simplify it and just kind of leave it like that. And so then they'll know exactly, because once you put that under there, they're going to wonder, well, okay, what kind of outreach? What kind of communication?
Yeah.
So,
Yeah, I look at it two different things. I see the communications director as somebody that's going to be hired in by the state. I look at an outreach position as something we probably should RFP and bring a group in to do the data collection and so forth.
right,
That was my view of it.
absolutely.
Karen,
That's why I look at it as two different things.
It's
Right.
listed as two different positions on page 14 of our binder. So I understand where Doug is coming from. So I kind of agree with him.
MC,
I wanted to offer that I'm imagining a consistent message. So I'm not against separating the two. What I am exploring is the reason that we might want to keep them together. And what I'm imagining is there's this in, right? We're going to be getting comments in from people. And I think this message, this communications person, the more that we have a message that allows people to know what we want, right? And get specific, that feels like a message. And it feels like we're also reaching out to communities that have a similar message. And then I'm imagining this person that we're hiring to direct the messaging, if you will, and then hiring interns or hiring sub staff, but one person to sort of help us message. And I don't think this person is going to be a webmaster, but I think that's a huge piece of what this is. And I don't see the webmaster position title here. I think that can be hired out. So I guess I'm not against separating them, and I'm trying to understand how we might benefit from having one person who helps us with our message, whether that's for messages coming in or reaching out.
well, it seems to me in reading through the responsibilities, et cetera, that this is primarily communications, not outreach.
I would agree. And if we do have outreach in here, it seems like we should really consider the communities of interest, right? Which is such a big criteria that was demonstrated, given to us. Yeah, so that's the communities of interest is missing from here. So I would agree that we can sort of look at an outreach director as separate. And this position is primarily communications, not outreach.
Any other comments? Anthony?
I don't see a reason why we can't look for somebody that has experience in both skill sets. I mean, this job, pays a pretty substantial amount. So, maybe finding one person that fits the criteria of both the things we want might be the way to go, just to, have less people hired monetarily. And then also if they start the job and then we find that they need more assistance, we could always, add on to our hiring. But I'm not opposed either way.
I would think that if you kept the letter with both of them in there, that you would more or less say you're looking for a person that's going to do communications with also this outreach, some kind of way we can put it together that one of the other things would be outreach, maybe something else we can kind of make some little pointers of the things that you that communicator would actually need in getting their staff together.
Anthony?
That is kind of how I read this under, maybe I'm wrong, but under responsibilities of communications director will include the following: develop and create and manage a public information campaign and program to meaningfully engage various audiences in the work of the commission. Consult and advise the commission and executive director on media issues, schedule media interviews, press conferences, all of the sorts. Yeah, I mean, to me, you know, all of these, the actual job description, like count for both communication and outreach. I mean, I may have a misunderstanding of what the difference is between the two.
Well, I think when you're thinking about outreach, that's someone that's got to go out and reach a whole lot of people at a certain amount of time. And communicator can just more or less do it in their own way of doing it. So it's probably almost like two jobs to me.
I guess the question is, regardless of what the title is, and if the title is communications and outreach, does the body of the posting cover both of those, or one of them, one or the other? And do we need to make any changes? Do we need to take out outreach? What do we need to do?
In order to make it fit with outreach, Steve, I would suggest that we do have under qualifications that we would add some demonstrated familiarity with communities of interest as defined by, you know, subsection 13C and section 6 of Article 4 in the Constitution. All right, it demonstrated familiarity with communities of interest as defined by Michigan's Constitution. I think it's subsection 13C.
But isn't it also some other things that would go under things that we have to look out for in redistricting the our job besides community interest?
Yes, and I would agree. My thought was that they are demonstrated, if we a little bit further down after qualifications, is desired skills and abilities. Well, and yeah, so we've got experience working with politically and socially controversial topics and environments, experiencing working with constituency-based media sources. I guess what I'm suggesting is those spoke to me as they could potentially help us demonstrate, yeah, what someone is going to be able to do, and working with a wide range of stakeholders. So I feel like we do have some pieces here for community outreach in the job description as it stands.
I can't see who's talking, but is that
That's
MC?
me. Yes, it's MC, Juanita.
Okay, I guess what I'm wondering is, would that be overwhelming for just that one staff to do, or would you want two different staffings doing that? So we
It's
take two
possible.
different people to do our outreach and then one to do our communications, because Michigan is large. And
It's
so
true.
that might be overwhelming for just one particular group to do all that.
It's true, and the way I'll say, Juanita, that I expect as a commissioner myself to be directed by this staff person to assist in gathering this information. So I don't think the person is doing the job themselves. They are just directing the campaign.
Staff.
And,
yeah.
Yeah, and it's a significant salary, just like the other ones that we've approved. And I guess what I'm suggesting is that I think we should try it. I think there are people who may be able to demonstrate the skill set. And I think the Secretary of State staff, frankly, has suggested this, and maybe they can speak to it, because there are people who fill this role, maybe, like, or there are people out there that they know of that might actually fill these abilities. And I guess that's my assumption. And so if the Secretary of State can speak to that, that'd be helpful. And I want, yeah, and then, as Anthony said earlier that we could hire somebody else too, if we need to, if this is too overwhelming.
Sally?
Well, that sounds great. That sounds good.
Yeah, hi everyone. So thanks, MC, and it's it's great to hear you all kind of the back and forth. Wanted to offer a little bit of context, and I think that the wording that we drafted in the title might have been overly confusing, so I apologize for that. Just to give you some context, at the Department of State, for example, we have a communications director. His formal title is Communications and External Affairs. I think his level of responsibility is probably larger and a little bit more all-encompassing than what you all would require. That said, the way this is written is to try and capture the need for whoever is responsible for your sort of media and public relations to help and work hand in hand with any additional staff you might hire to do that outreach work or to do that kind of public engagement work. Just for example, at the Department of State, our public engagement team works really closely with our communications director to make sure that the messaging and the public education campaign and everything is in lockstep. So the way that, in thinking about this and in drafting it, and again, just, a starting place for you all really truly is that it was drafted to be flexible so that you could look for top tier talent, but if it's easier to just remove the and outreach from the title so that it's clear that this person's central role is sort of the communication side of things, not the actual doing of the organizing town halls, for example, then that might be something to consider. The other note I would just make, MC, on your recommendation to add mention of communities of interest is to perhaps put that in the desired skills and abilities section instead of the qualifications, just, to differentiate, because many people might not even know the term communities of interest, even if they would be a great communications director for you all. So that's just some thoughts. And again, I apologize if the title used kind of created more confusion than it was helpful.
Well, I like the way you just said it, though. Sounds good the way you put it.
Any further comments? Do we want to move forward with this? Do we have changes we want to make, or do we want to table it for till the next meeting and think about it?
I believe Mike just got his camera working and had something to say on this. Mike, can you hear us?
I can. Can you hear me?
Yes.
And unfortunately, we can see you also.
Bless you, sir. Yeah, I was gonna. One thing I was gonna add additionally to what Sally said, and certainly, echoing, I think, the feedback from Juanita and others, is that they are in fact different roles. One of the things that I know from other public entities, especially some of the smaller public entities, frankly, which is what this commission is that if they have a communications person on staff, and some, actually will engage an outside communications firm, because the nature of the work is, frankly, fits and starts. So, I mean, to think about it at this point, think of the last 2 weeks of meetings. Think about what your public announcements look like right now. It's not always going to be like this, of course, but it's also not going to always be, 100% on, full either. And so thinking about, frankly, thinking about how they're, maybe, especially with the amount of money that has been proposed, you can really command top talent, especially people who are interested in serving and just all the experience and, frankly, exposure that they're going to get for the rest of their career because they worked with you. So when you combine that opportunity plus the amount of money, you can command top talent. And I'll just tell you, there are definitely people out there who, and communications and outreach, Juanita is absolutely right. They are different things, but there are people out there who do both. And in a lot of cases, they do both as a practical necessity because their clients or their employers can't afford to have more than one. You all have your own budget. You can make that decision. The reason that the recommendation from the Department of Staff is what it is to try to bring these two together initially out the gate for you all. And of course, it's your call, was frankly out of, among other things, a knowledge, or the knowledge that there are a lot of folks who have experience and actually know how to do both distinct skill sets, but also being very mindful and trying to, of the taxpayer dollars that will pay for these salaries, and trying to be fiscally responsible with that. So practically speaking, again, I think other folks have already, Juanita said this much better than I can, but in a certain regard, you know, some people I've heard it said think of communications as putting a message out. They think of outreach as taking information in. Obviously, a good, effective dialogue involves both speaking and listening, both putting information out so the public knows what you're doing, but also receiving information back so the public's input can inform what you're doing. And it's both of those things. And so at any point, if it's too much work for somebody, you can and perhaps should, you know, add additional staff capacity. But just thinking about, you know, practically speaking, if this person was on, if not now, but let's say this person comes on a month from now, or even, you know, in December, there's going to be a lot of other, you know, frankly, lull times. There's not going to be huge announcements necessarily as this commission does its core work that would require necessarily, you hope, you know, that's not when you should be sued, right? The big lawsuit comes later, the other things come later. So in terms of communication and outreach, I'm sorry, in terms of communication and putting messaging out and speaking with the media, that's going to feel different than at other points in the schedule. And in terms of the outreach, I'm thinking about somebody who, like, they're not going on your behalf. The Constitution requires you all to have meetings. We've talked about this before, 10 meetings at a certain point, and at least 10 meetings at a certain point, and at least 5 meetings at a different point. And so the outreach person is somebody who can, you know, maybe they're going out doing advanced work. They're certainly working, they're facilitating those conversations on your behalf with you in the room. So they're not really kind of going out doing this whole other thing. It's not a whole separate team. You're the outreach, actually, somebody who's supporting you, but that's a distinct skill set. So that's a little bit of the rationale. Obviously, you know, as you know already, you do whatever you need to do. You know, we stand ready to support whatever you decide.
Thank you, Mike. Appreciate that. Any further comment? Do Juanita?
Yeah. I like what Mike said. Maybe we should try it that way. And if it becomes overwhelming, we'll kind of separate the two.
Okay.
Agreed.
And hire someone.
Aaron.
If we're going to combine the two, do we want to put under responsibilities that, going from page 14 of our binder, the communications director, no, the outreach director is supposed to organize the public hearings, because I didn't see where that was clearly defined in this.
It's a great addition.
Could it, Aaron, I wondered, I was looking at that too, and I thought under the responsibilities to develop and create a public information campaign and program to meaningfully engage, do you want more definition than that?
I just wondered if that encompassed actually organizing the public hearings with what DOJ has done. DOJ has done.
I'm okay with further definition.
Yeah, I think we can add that in. I don't see why not, for clarity.
Does somebody have proposed? Oh, I see. And organized public hearings. Okay.
Steve, what about responsibility of compiling the public input? And then summarizing and presenting that data to the commission?
I guess my thought, personally on that is just having listened to what California said. I mean, they had 30,000 of those, and they were doing, if we got 100 of them that are all on the same topic, we got one with times 100. I think that we would be wise to take a wait and see attitude and see how much we got coming in, and if we need to have staff organizing those. I wouldn't think we would be paying somebody $120,000 to organize emails coming in, be paying a secretary.
No, they may manage the organization of that though.
Yeah, I don't see that as a problem.
Okay.
Anybody, are we a point to make a notion, because we're at a point, we're coming out of time.
Okay, so I'll motion to adopt this job description.
As
And I
amended,
will second that.
as amended.
Yes, as amended.
Okay, second.
I second that.
Okay, motion by Anthony, second by Dustin to adopt the proposed communications and outreach job posting as amended. All in favor, say aye.
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 I,
All opposed, the same sign. Okay. I would now entertain a motion that we direct the staff to post the position.
I also second that.
Who made the
I'll,
motion?
I'll, I'll
Dustin.
move it. MC moved it.
MC
Dustin
moved.
seconded.
Dustin seconded that the staff post the communications and outreach director job posting. All in favor, say aye.
Aye.
I,
All opposed, the same sign. Okay. Are there any final thoughts? I mean, we're at the point of adjournment. Anything that we need to think about before I ask Sally questions?
I just want to say, I sent out Sally, I sent to Sally, then Sally sent them out to you guys, some just different proposed motions I came up with. I thought we'd be talking about compensation today, so I thought they'd be a good starting point. I know Brittany wanted to talk about it too, and she's not here, so I think it's, it's good that we're going to be getting more information from the Secretary of State later. But we'll give it a read, so we hopefully have a starting point to go on whenever we talk about it. I would appreciate it. It's formatted more so in the format of a resolution instead of a motion, but I think it gets the job done.
I did get those and I did look at them. And I guess my comment would be 2 of them are really non-starters because they don't comply with the constitutional amendment.
Being
Well,
what?
I thought they did comply.
You got 2 of them are too high. They're over
I
25%.
thought the Constitution said that minimum of 25%.
Correct.
That's true. And I guess my comment there would be, it's gonna be awful hard to go above 25%.
Yeah, I mean, I don't support going above 25%, but I think it's justifiable under the Constitution.
While it is a floor, it is really a ceiling.
Yeah,
If anyone-
I just made them for, we can discuss that whenever we discuss it. But I think I'm not necessarily in support or not in support of it being more than 25% yet. And we can discuss that later, but I don't think that it doesn't comply with the Constitution. I'm pretty sure it does comply with it.
I have a question.
Okay, Juanita.
Do anybody remember when they applied for this service job that it said that the compensation would be $54,000?
I don't recall that.
I don't recall that.
Okay, I'm the only one. Okay, just wondered.
Okay, Sally, do you have anything for us? And do you have the numbers I asked you for?
I think Mike has something for.
Mike.
Hi, I was just more for the public. Anthony mentioned that he had a few different proposed resolutions that he had shared with Department of State staff to share with the commissioners. Those were shared. All of those will be posted online if they haven't already been, so that people understand, what's being proposed. I think there was 3 different resolutions. They all dealt with, again, this is just for the public, so they understand what was actually being discussed just now. 3 different proposals for compensation. One of them included the 25% that's included in the Constitution. And then there's one that went above that and one that went further above that. And so there's not a motion today, but if anyone in the public is interested in seeing those, you can see them at redistrictingmichigan.org. And so just wanted to flag that.
Thank you guys so much for posting that.
Okay, Sally.
Hi, commissioners. So I think we are all set. I just wanted to recap that old business for next week, or sorry, not next week, next meeting will include the thank you notes and code of conduct, and we will be posting the communications director position along with the general counsel on Monday.
And do you have the budget numbers that were given out to at the start of the meeting?
Yes. So the fiscal year 21 budget for the commission is $3,149,400. So the 25% of the governor's salary for fiscal year 21 is $39,825, which would be the compensation outlined in the Constitution. And then the remainder, so basically the fiscal year 21 redistricting budget minus that compensation for all 13 commissioners leaves $2,631,675.
Thank you. Okay, anything else from anybody?
Steve, one thing, on the next meeting agenda, can we have line items for forming the committees for the two other jobs we posted, which I believe were the general counsel and the communication and outreach director?
For the agenda?
Yeah, for the agenda.
Yes.
Sure. Yeah.
Yes.
Anybody else? Don't see any hands. Juanita, we can't see you, but we can hear you. You got anything for us?
Not right now.
Okay, would you
We
make a
can see
motion?
you guys.
Would you make a motion we adjourn, Juanita?
I make the motion. I move that we adjourn.
Cynthia, will you second it?
Did.
All in favor, get up and walk away.
Thanks.
See you
all
next
have a
meeting.
blessed day.
See you later.
When is the next meeting?
Next meeting.
It's on the 12th, October 12th.
Okay.
Oh, excuse me, October 13th, Tuesday, October 13th. At 1 o'clock.
Alrighty.
You all have
Okay.
a great weekend.